Who do we have? Who do we have first?
Yes, Judge, this is position 18, Mr. Hill.
Good afternoon, Mr. Hill. I'm Judge Eric Moore. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Hill, you've been charged in case 22 CR 005072A with simple battery. Is there a history, Mr. Howard? Doesn't look like Mr. Howard is with us yet. Mr. Segura, good afternoon.
Good afternoon, Your Honor. In regards to this history, I'll explain it after my narrative.
Okay, thank you.
Okay, this case occurred both yesterday and today, in which the officer responded to the speed call at 1555 Duville Court, Northwest, Atlanta. Duville spelled D-E-A-U-V-I-L-L-E. In this case, is in contact with the victim, Ashley Thomas. Ashley, common spelling, Thomas, common spelling. She stated that yesterday at around 7:30 p.m., she was trying to get her children prepared for school in the morning. By that point, the defendant became angry, did not like this, and then a verbal altercation began. At that point, the verbal altercation exploded, which at some point, the defendant pushed Ms. Thomas onto her bed, and then got on top of her, put his elbow against her throat and in an attempt to restrain her. At this point, Ms. Thomas tried to break free from his grasp, but this ended up with the defendant striking Ms. Thomas on her chin with the defendant's elbow, causing her to bite her bottom lip. At that point, the defendant left, but he actually came back today, this morning, August the 1st, at around 1 a.m. At this point, the defendant tried to enter the location, but Ms. Thomas would not allow him to get in. So at that point, the defendant became angry, went to the side of the house to switch the power to the house off in an effort to force Ms. Thomas to go outside and does allow him to actually enter, which once approached by police, the defendant did admit. And police were able to find the defendant when he was in a crawl space in which which was pried open. Your Honor, the state was recommending a $5,000 cash bond for the reasons we'll soon explain, with the conditions of a one-day anger awareness, no alcohol, drugs, and weapons, a stay away from the 1555 Duville Court, Northwest Atlanta, and no further contact with Ashley Thomas. Your Honor, we have deep concerns about the safety of Ms. Thomas. We spoke for audio today, in which she stated that both she and the defendant are married, they live together, and have 4 children. She said she mostly confirmed the main warrant narrative, that she was paying children for school in the morning, but she also added several facts that were not in the warrant. Namely, that the defendant came in, he was screaming, yelling, then cussing at her. Once the defendant actually pushed Ms. Thomas under the bed and started to put his elbow to her neck, she then added, which is new, that the defendant tried to choke her, and she said that the defendant did apply pressure, but she was able to breathe and not lose consciousness. She said she was trying to break free from his grasp, which at that point, the defendant did strike her with his elbow to her chin, which in fact did cause her to bleed. And Your Honor, it's not the first time this happened. This is a court open case against the defendant, which occurred on September the 3rd, 2020, which is at 21 CP 198750, which is an aggravated assault strangulation. In this case, Your Honor, in this strangulation case, it was about a fight about car insurance, in which the defendant told Ms. Thomas to pay for the car insurance, when she refused to do so, the defendant choked her by squeezing her neck with her arm, but he was standing behind her. At that point, things escalated, and then the defendant threw Ms. Thomas under the ground, and she was struggled to break free because, as Ms. Thomas stated, she couldn't breathe and was trying to escape him. At that point, it was so loud that all four of her children in the house were able to actually hear this. And because of this, and at some point, the defendant also grabbed Ms. Thomas by her head, pulled her up with her hair, causing her to go back on her feet. And this caused actually, Your Honor, for her hair to be whipped off her head. And in this, the defendant was given a $20,000 good bond with a stay away condition for Ms. Thomas. But Your Honor, as you can see, The defendant did not abide by these conditions. He in fact broke it, came back to Ms. Thomas, and then injured her again. Now back to Ms. Thomas, she also stated that since the strangulation incident, there were more acts of violence that occurred, but she did not call the police because she was trying to make the relationship work for the safety of the children. But Your Honor, things kept escalating. In fact, Ms. Thomas stated that 3 weeks ago, the defendant got a screwdriver, put the screwdriver to her neck, and then stated, quote, "I should have killed you." And not only that, the defendant kept trying to make Ms. Thomas suffer, but saying he's trying to get the kids away from her because they know that'll be painful for her. Alongside, Ms. Thomas stated that she wants to have the defendant have no contact both with her and her children, but knows he will not abide by any court order, and that if he is released, he will come back. Because as Your Honor knows, there was a felony case in which he had a good bond, which even that did not stop the defendant from returning to Ms. Thomas to cause her harm and injury. Alongside, she also stated that she wants to stay away from her home and will drop off the belongings at the police department to retrieve her belongings because she's deeply afraid. Your Honor, the defendant is not the first time that the defendant has a domestic violence history. In fact, he has one in Alabama from 2016 with his ex-wife. You know, these are not the same victims. This is an issue of itself because it shows that the defendant will beat women who are near him. In fact, in this Alabama case in 2016, it was his ex-wife, and these 2 recent cases are now his present wife. And this all shows that it's a cycle of domestic violence. And it clearly shows that there is no sign of this stopping and will only continue. And based by these recent acts of violence, it only escalated to the point where Ms. Thomas could meet death. In fact, she's on Zoom today, but she was unsure if she wants to speak because she told her office this morning that she was so afraid of the defendant, she knows he'll get angry, he'll return, and she feels that he will kill her. And because of this, we're asking for a cash bond, Your Honor. Thank you.
Mr. Howard, is there any history that Mr. Segura has not already informed me of?
No.
Okay, thank you. Ms. Kim?
Yes, Your Honor. Mr. Hill is 38 years old. And yes, they do live together, and they're married right now, and they have 4 children together. Right now, the house or place is in Ashley Thomas's name. So my client does not oppose to stay away at this point, and yet he believes that she was not angry anymore and she was going to be okay for no further violent contact. And yet I did not have a chance to talk to her myself. So and he has been here in Georgia for a year. And they have 4-year-old twins and 10 years old. They're all minors, and he's the primary person who provides financial means to the family. And their mother is, Mr. Hill's mother is very, very sick, and Mr. Hill has had disability ever since he was 7 years old. So he gets SSI check, and his education level, the highest one he has completed is 10th grade. Right now, he is working on GED because he has a goal to get 18-wheelers, a truck driver license. So he's been working very hard toward getting that license so he can provide more financially. We would like to request for surety bond instead of a cash bond. We would like to request for $1,000 maximum surety bond, Your Honor. Thank you.
Ms. Kim, do you want to speak to the stay away that he was supposed to abide by for the alleged aggravated assault charge?
I don't think he was not really, I don't think he understood that he had to stay away like that.
Okay, well, I'll make sure that he understands this time. Mr. Hill, you ought to have no further contact whatsoever with Ms. Ashley Thomas. No contact means no phone contact, no email contact, no social media contact, no personal contact, no contact whatsoever. Do you understand that?
Yes, sir.
All right, you also stay away from the 1555 Duville Court address. You can go back to that address on one occasion with law enforcement to obtain any belongings that you might have there. It's going to be a $5,000 cash bond, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hill.
Thank you, sir.
Thank you, Your Honor.
Position 24, Morgan. Where's Morgan?
Two more.
You, Christian Morgan.
Good afternoon, Mr. Morgan. I'm Judge Eric Mora. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Understand, yeah.
Thank you. Mr. Morgan, you've been charged in case 22 CR 005049C with theft by taking, criminal trespass, public drunk, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
His ninth arrest. Last was in March. Trespass, misdemeanor possession of marijuana. 2019 simple assault, terroristic threats. They were NOD. 2018 FTA NOD. 2017 FTA NOD. He was convicted in 2017, 2 counts of suspended license. And before there was a 04 possession of a firearm during the commission. Carrying pistol without a license, sale of marijuana, and carrying concealed weapon. It was a dead docket. That's it.
Okay. Good afternoon, Ms. King.
My apologies. Good afternoon, Your Honor. This is Christian Morgan. On 7:30, officers were patrolling the 5 Points MARTA station. And the defendant did come inside after receiving a criminal trespass warning the previous day. And he was advised by the police personnel on scene that he was not to return. It was understood that he was not to come back. And they actually told him that he would be arrested and taken to jail if he did return. This time when he returned, he was in an intoxicated condition. He was being very boisterous and he was using vulgar language. The defendant made contact with the victim of this case, Mr. Wade Smith, while he was inside of the station. He was charging his phone. The defendant came up and actually snatched the phone off the charger and walked away. The victim even said that he told him he was not giving him the phone back, which shows that he intended to take the phone and not return it to the victim in this case. The officers made contact with him and tried to detain him at that point, and he was keeping his wrist from being detained and even was pulling away as if he was trying to flee. The state feels this is a big problem. He has an open criminal trespass out of Clayton County at this time, as well as felony charges, felony convictions, Your Honor. The state is concerned due to this being a random act of, while it might not be violence, but snatching someone's personal property and something as vital as a phone can be felt as something violent towards a victim. Furthermore, he's coming to places that he is not supposed to be. He was warned the day before, so he can't say he forgot or anything like that. And then he's out in public drunk, Your Honor. This is a problematic situation, and that's why the state is requesting a $5,000 surety. That's $2,000 for the criminal trespass and $1,000 on all other counts. A stay away from the 5 Points MARTA station located at 30 Alabama Street in Atlanta, and no further contact with the victim, Wade Smith, and no drugs, alcohol, or weapons while out on bond.
Good afternoon, Ms. McLeod.
Good afternoon, Your Honor. My client is 39 years old. He is a native of Atlanta. He denies the allegations made by the prosecutor. He denies taking someone's phone. He tells me that he uses MARTA very regularly to go to and from work, and this is not the first time that he has been harassed by MARTA police. He has no other way of getting around, Your Honor. My client only has an 8th grade education. He tells me that he should have started a new job today, as a matter of fact, working for Pepsi. He tells me that he's currently homeless, but he has skills working in a warehouse and also as a forklift operator. As I said, Your Honor, he is currently homeless. He's not in a position to pay bond. This alleged victim is not someone that he really has to interact with. He absolutely denies that he was warned by Martha not to use Martha. He says he's used Martha for years, and that is a way of getting around because he does not have a car and he was not aware that there was a criminal trespass warning in place. I would ask the court to consider giving him a signature bond, given the nature of the allegations, so he can get out and try to get to this job which he was supposed to go to today. He, as I said, he doesn't have a place to live. He's homeless. Thank you, Your Honor.
Your
Yes,
Honor,
sir.
if I may, the offense on 729, the criminal trespass warning, was captured on CCTV, MARTA CCTV, and the offense on 730 was also captured on CCTV.
Okay, thank you, Ms. King. It's going to be a $500 signature bond through the jail on each count, which makes it a $2,000 signature bond through the jails. No further contact with Wade Smith. Stay away from 30 Alabama Street, MARTA Station. No drugs, alcohol, weapons while out on bond. Mr. Morgan, I'm going to let you out, okay? But you can't go back to the 30 Alabama Street, MARTA Station. You understand that?
Can I ask something? How I'm gonna get to work then?
You can go, you just can't go to that station. You can use MARTA, but you can't go to the Alabama Street Station.
All right.
Okay?
Yes, sir.
All right. Good luck to you, Mr. Morgan.
Thank you, Your Honor.
You're welcome. Who do we have next?
Next, we have Mr. Turner, position 27. That was the total with the 2,000 signature bond through the jail, correct?
Yes, that's correct.
Thank you.
Good afternoon, Mr. Turner. I'm Judge Eric Moore. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I do.
Thank you. Mr. Turner, you've been charged in case 22 CR 005051F with loitering and prowling, possession and use of drug-related objects, and criminal trespass. Is there a history, Mr. Howard?
17 total between Georgia and Illinois. Last arrest was March 2021, theft by taking. He's out on pretrial for that. That's 21 CP 198317. 2018, he was sentenced to 5 years probation, September, for theft by taking. So he's on, that's 18 SC 161635. 2020 probation violation, 2018 FTA simple assault. He had a 2018 simple assault conviction, 2016 robbery conviction out of DeKalb, and a robbery conviction 2009, I think, out of Illinois. That's it.
Ms. King?
Yes, Your Honor. On July 29th, officers were patrolling the parking deck when he observed the defendant wearing a red shirt, black pants, black gloves, and having a white shirt covering his head and face while entering the Lindbergh MARTA station parking deck. At that point, the officer told the defendant that he had to leave. 40 minutes later, 5 male subjects, including the defendant, walked into the parking deck again, and this officer observed all of this. He told him to leave again, and another officer actually told him that he told him to leave separately. So this is 3 separate times, two different officers told him to leave the place. At this time, the defendant started to get belligerent and get an attitude with the officer, saying that, asking why he was bothering him. And the officer told him, he was like, because we told you to leave the parking deck. And then he even asked him, do you have a car here? And he says, no, he's waiting for a ride. That is where the loitering charge stems from. The criminal trespass stems from them asking him to leave and him returning. And when he was detained, he had what appeared to be a crack pipe on his person. That was in a bag that was on his person. That's where these 3 charges stem from. The state is requesting that the $1,500 surety remain in place, a stay away from the Lindbergh MARTA station located at 2420 Piedmont Road in Atlanta, and no drugs, alcohol, or weapons while out on bond.
Is that 500 apiece?
Yes, Your Honor, that's how it's broken down.
Ms. Kim?
Yes, Your Honor. Mr. Turner is 31 years old, and he has been here in Georgia for 1 year. He moved from Illinois, and he does not have anybody who can bail him out right now except his godfather, who he cannot have phone number from the smartphone lately. Nobody really memorized his phone number. He graduated from high school, and he also has a 1 year of degree in, not degree, 1 year of college education to be a medical assistant. And today was actually, Saturday was his first day orientation at a restaurant that he was going to work. However, he is afraid that he's going to lose that job if he does not get out today. And he has disability evaluation this coming September at Grady, so he can get SSI income through the Social Security Administration. We would like to request for a signature on bond. His financial means are very, very tight, and he does not have any way to pay for the bond at this point. So $1,500 signature on bond would be great for him. Thank you.
All right, it's going to be a $500 signature bond through the jail for each count, which makes it a $1,500 signature bond through the jail. Stay away from the Lindbergh MARTA station. No drugs, alcohol, weapons while out on bond. Mr. Turner, I'm going to let you out, but you're going to have to make sure that you show back up for your next hearing date. Otherwise, they're going to put a warrant out for you, okay? All right, you need to stay away from the Lindbergh MARTA station. Don't go back there.
Yes, sir.
All right, good luck to you, Mr. Turner.
Thank you, sir.
You're welcome.
Position 23, have a seat. Position 23, you're done. Have a seat. Yeah. Position 23, Mr. Moore.
Good afternoon, Mr. Moore and Judge Eric Moore. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Moore, you've been charged in case 22 CR 005048J with theft by shoplifting. Is there a history, Mr. Howard?
It's fifth arrest. Last was 2016 suspended license. It was dismissed. 2016 suspended license NOLO and a marijuana possession conviction. 2013. That's it.
Ms. King?
On yesterday at around 1 p.m., officers were dispatched to the Walmart located at 5200 Windward Parkway in reference to a shoplifting in progress. When officers arrived, they were advised that the defendant had already left the premises. They were able to give a description of him about his shirt and as well as what he had in his property, as well as what he took. They said that he was heading towards the Home Depot that was like down the street from it. So the officers started to canvass the area. As soon as he got near the Home Depot, he saw the person matching the description, and the officer pulled over to speak to him. When they were trying to talk to him, he was ignoring their commands and he was continuing to walk. So the officer took out his taser, and at that point, the defendant dropped his bags and started to speak to him. At that point, they were able to detain him and get him to the ground and detain him while they spoke with him. They were able to find the property inside of the bags on his person. The property that they told was stolen. He also had a firearm in his bag. It was not reported stolen and it was not loaded, which is why there's no charge for that. And at that point, he was taken into custody. Right now, there's a $1,500 surety. The state is requesting a $3,000 signature due to his lack of history and due to the store getting their property back. But we are asking for a stay away from that Walmart location at 5200 Windward Way Parkway in Alpharetta, and no drugs, alcohol, or weapons while out on bond.
Any objection to that, Ms. Kim?
No, Your Honor. Is it going to be a signature bond through jail or?
It's going to be through pretrial. $3,000 signature bond through pretrial. Stay away from the Walmart at Windward Parkway. No drugs, alcohol, weapons while out on bond. All
Thank
right.
you, Your Honor.
You're welcome. Good luck to you, Mr. Moore.
All right, you're done. $3,000 signature bond. Next is position 25, Pierre. 2,000 signature.
And good morning, Your Honor. This is a cross-defendant case. We could hear both their cases at the same time since it's a very long calendar. Not sure.
Who is the cross defendant?
I believe the cross-defendant is Akin.
Position 2.
Yes.
Position 2, so can we take position 2 next?
What's the name?
The name is,
Ms.
Oh.
Nicole Anya DK.
Yeah, she's not ready yet. She's not in here.
okay, all right, so thank you, Ms. Tortorella, but I'll remember the facts for that position so that you can do a briefer recitation. Good afternoon, Mr. Pierre. I'm Judge Eric Moore. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do, Your Honor.
Thank you. Mr. Pierre, you've been charged in case 22 CR 005079Y with simple battery. Is there history, Mr. Howard?
This first, he a resident of Florida.
All right, Ms. Tortorella.
Yes, Your Honor. For the simple battery charge, a $3,000 surety bond, the conditions is that he have no contact with the cross defendant. Her name is Nicole Anya DK. That's Nicole. Last name is Anyadike. To stay away from the Hyatt Regency at 265 Peachtree Street in Atlanta. 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, on July 31st, 2022, an Officer T. Chambers of the Atlanta Police Department was dispatched to the Hyatt Regency at 265 Peachtree Street in Atlanta in reference to a domestic dispute. Upon arrival, the officer spoke with the cross-defendant, Nicole Anyadike, who said she and the defendant, Jerry Pierre, were having an argument in the vehicle when the defendant struck her on the side of her neck. The defendant did admit to the officer that he hit the cross-defendant, but only in self-defense of the cross-defendant hitting him in the nose with a closed fist. The defendant advised that once inside the hotel room, he attempted to leave, but the cross-defendant did not allow him to. Defendant said he began to record the cross-defendant, and the cross-defendant then became violent towards him, and the defendant did suffer minor scratches. Both parties were arrested, and these events did occur in Fulton County, Georgia. Your Honor, we understand the very light criminal history. However, we just heard from pretrial he does have an arrest out of Florida. To add, Your Honor, not only does this make him a multi-state offender, he's also a flight risk. He does not live in Georgia and has no ties to, apparently has no ties to the state. For that reason, Your Honor, we are asking for a $3,000 surety bond. The conditions, again, no contact with the cross-defendant, to stay away from the incident location, 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Nothing further.
You said one arrest out of Florida or no arrest?
No arrest.
Did you say, I'm sorry, if that was the case, I apologize to the court. He has no arrest. However, he does live out of state.
Ms. McLeod, who is Ms. Anyadike to Mr. Pierre?
She is the mother of his 9-month-old son, Your Honor. They do share a child together. He is the legal father of the child.
Okay, Ms. Thomas, is Ms. Anyadike your client?
Yes, Your Honor.
What is her view as far as contact goes?
She does not wish to have any contact with him.
Okay. So it's going to be, Ms. McLeod, if it's all right with you, a $3,000 signature bond through the jail. Stay away from the 265 Peachtree Street. I don't know if he has any belongings there, but he can go back there on one occasion.
It's a hotel, Your Honor, and they were actually on vacation. They just come to Georgia. They just arrived here. He does live in Florida. He has a business which he's had since 2011 in Florida.
Okay, I'm just wondering, does he need to go back to the hotel to get any belongings?
I believe he does, Your Honor.
Okay, so he can have a one-time police escort to go back there to pick up any belongings that he might have there. No further contact with Ms. Anyadike, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. McLeod?
Yes, Your Honor, if that is what she wants. My client had said no further violent contact because he says she was aggressive, but he's not really afraid of her. And they do share a rather young child, a 9-month-old son.
Well, if she doesn't want contact, I'm gonna go with her wishes. He can have a third-party contact for child visitation.
That
Okay,
would be fine, Your Honor.
And
All
Your Honor, the state will be upgrading these charges to family violence.
Okay, well, at the present time, he's only charged with simple battery, so, good luck to you, Mr. Pierre.
He has a
Um,
question.
Your client has his hand up, Ms. McLeod?
Yes, Mr. Pierre, is this about your bond?
Yes, I was the one to notify you guys in reference to the domestic. I have video.
Yes, that's okay. We're not talking about your case now. We're just addressing the issue of your bond. So keep your videos. This will come in handy at the time of your trial, but it's just about your bond now. You've been given a signature bond by the court, so you'll be able to sign your own bond to get out.
Would I be able to fly back to Florida as well, or am I going to have to stay?
Well, yes, that's your home, and there's no condition of the bond that you don't leave the state of Georgia. So yes, you'll be able to fly back to Florida. You do have to come back if they were for your court appearances.
Thank you very much.
You're welcome.
All right, good luck to you, sir. Who do we have next?
Position 8, Dawson.
I gave you hers. I want to take yours.
Good afternoon, Mr. Dawson. I'm Judge Eric Moore. This is the, let's not feel bad. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
I guess so, yes, sir.
Okay, thank you, Mr. Dawson. You've been charged in case 22 CR 005075B with simple battery. Is there a history, Mr. Howard?
Fourth arrest. Last was 2011, simple assault. 2009 trespass conviction. 08 possession of marijuana. Dead doctor. That's it.
All right, Ms. Tortorella.
Yes, Your Honor, for the simple battery charge, a $4,000 surety bond. Conditions is that he have no contact with the victim, Gary Goss, traditional spelling, to stay away from 1385 Sharon Street Northwest in Atlanta. 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, on July 30th, 2022, at 1385 Sharon Street in Atlanta, defendant Poinyavius Dawson did strike Mr. Gary Goss multiple times with a closed fist in the face. The Atlanta Police Department responded to the scene and met with the victim, Mr. Goss, who had bruises and cuts on the side of his face and was being treated by the fire department. Mr. Goss said he was attacked by the defendant when he was trying to prevent him from entering the property belonging to witness Reggie White. Mr. Goss said the defendant began to choke him and struck him several times on the side of his face where he started to bleed. The defendant was arrested, and these events did occur in Fulton County, Georgia. Your Honor, he has 4 cycles. You understand that these, what I'm about to read is quite remote. However, we are facing a violent charge today, and I believe this is important to state. On December 16, 2011, he was arrested for simple assault by the Atlanta Police Department. And in June 19, 2009, he pled guilty to criminal trespass in Fulton State Court. Your Honor, we do have concerns that there is no connection between the victim and the defendant, and he just decided to punch him and choke him. So for that reason, Your Honor, we're also concerned for the public safety and the citizens of Fulton County. And for that reason, we're asking for that $4,000 surety bond. And the state will be upgrading this to a battery, nothing further.
Ms. McLeod.
Yes, Your Honor. My client is 32 years old. He's a native of Atlanta. He currently is studying at the Walker Family Center in Jonesboro. He tells me that he's studying music. My client lives in a group home situation, Your Honor, because he needs to be in that environment. He does not have any family around here. We've spoken about that. He says that Mr. Goss, the alleged victim, actually attacked him. He was going to the refrigerator to get some water because he was feeling dehydrated when he was attacked by Mr. Goss, and he was merely defending himself. The court will see that my client has no significant history. The last time he was arrested was in 2011, which is more than 10 years ago. It's about 12 years ago. It's been some time. He is definitely not a threat to anyone, since this is remote, Your Honor, and this is a situation where he was actually attacked by someone else and he was just trying to defend himself. He doesn't have anywhere else to go, Your Honor. He lives in this group home situation. If he is barred from going there, he will be homeless out on the street. I would ask the court to take that into consideration in setting his bond, and he doesn't have any money to pay for a bond, Your Honor. Considering the nature of the allegations, I think he's a good candidate for signature bond, and I would ask the court to give him one with no further violent contact between himself and Mr. Goss. Thank you, Your Honor.
Your Honor, we object to the no further violent contact. The victim's not here to speak, and we will also object for him to return to the property. There was a witness there, Mr. Reggie White, and he did strike and choke the victim there. So for that reason, we do feel that he is a public safety concern and intimidation of the victims and witness in that location, Your Honor.
Okay, Ms. McLean, I'm going to give him a signature bond. It's going to be a $3,000 signature bond through the jail. Although, is the Sharon Street address the group home?
Yes, Your Honor.
All right, and Mr. Goss, I take it, is at that home also?
That's my understanding, Your Honor.
All right, so it's going to be no further contact with Mr. Goss, and given that there's no further contact with Mr. Goss and he lives at the Sharon Street address, stay away from the 1385 Sharon Street address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Dawson.
Thank you, sir.
Yeah. Position 21, Mr. Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Jones, you've been charged in case 22 CR 005046Y with criminal trespass and damage to property and obstruction of a law enforcement officer. Is your history, Mr. Howard?
I don't have that one. My coworker has it because he went to felony, apparently.
All right. Ms. King?
Yes, Your Honor. We have 28 cycles. And yes, he has the Oprah robbery, which is where he was seen in first appearance this morning. When I checked, I didn't see a bond. I don't know if there's a delay in Odyssey, why I can't see what bond he received. He also has simple assault conviction from 2011, a simple battery and obstruction and false name conviction from 2005, and a DUI conviction from 2008. There are other violent convictions, but they stem later in time. He does have a battery family violence arrest. It was null pros. That's from 2011. And then before you today, this offense occurred on July 14th. Officers were dispatched to 335 Big Sky Pass Southwest in reference to a domestic dispute. When he came on scene, he met with the victim in this case, Ms. Jacqueline Elliott, JACQUELYN, last name ELLIOTT. She stated they were arguing, and she said that while he was talking, he hit the window of the vehicle and in essence shattered it. And then she says that he continued to punch windows due to his anger even after breaking that one. The officers were able to observe bruises on his hands to show how he broke the windows. The officer asked him for his driver's license, and he stated it was inside of the home, the incident location. Then he went inside the residence and never came out. Someone else, they presume it was a nephew, came outside and stated that he went out the back door and left the residence. Officers drove around the neighborhood, but they were not able to find him. So that's when they took out the warrants, and he was ultimately captured when he committed the robbery on yesterday, or early this morning. The bond is currently set at $2,000, a $2,000 surety. The state is requesting an increase to a $4,000 surety. No further contact with the victim, Jacqueline Elliott. and a stay away from the incident location, 335 Big Sky Pass Southwest in Atlanta, and no drugs, alcohol, or weapons while out on bond.
Ms. McLeod?
Yes, Your Honor. My client is 41 years old. He is a native of Atlanta. He tells me that he has been disabled for some time, Your Honor, and is currently not employed due to his disability. He denies the allegations that the prosecution has made. Also, he tells me that to his recollection, this incident happened sometime in 2020. He also tells me that he does not live with the alleged victim and they have never lived together. He lives in Atlanta with his sister, Your Honor. I would ask the court to take these facts into consideration in setting his bond. Apparently, he has some other issue going on for which, of course, this court is not going to be setting his bond, but he does have to post bond in that case, Your Honor. I'd ask the court to take that into consideration in setting his bond. Thank you, Your Honor.
Okay. I was told that he hasn't gone to felony yet for the alleged robbery. So for this, the criminal trespass and the obstruction is going to be $1,000 signature bond through the jail on each count, $2,000 signature bond through the jail total. Stay away from Jacqueline Elliott, or no further contact with Miss Elliott. Stay away from 335 Big Sky Pass. No drugs, alcohol, or weapons while out on bond.
Your Honor, the state would just like the record to reflect the strong objection to a signature bond in this case. This offense occurred weeks ago, and he was not able to be apprehended. The only reason why he was apprehended was because he committed another offense, Your Honor. So the state just wants the record to be clear.
Objection noted, and it's on the record. Thank you, Ms. King. Who do we have next?
Position 12, Goodman.
Good afternoon, Mr. Goodman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Goodman, you've been charged in case 22 CR 005056Y with criminal trespass, giving false information to law enforcement, and willful obstruction of law enforcement. Is there a history, Mr. Howard?
Second arrest, 2020 shoplifting out of Cobb County. He's wanted out of Cobb, FTA warrant, larceny from building. It's the shoplifting. That's it.
Mr. Segura?
This occurred on July the 30th, 2022 at the 10th on West, an apartment complex located at 1010 West Peachtree Street, Northwest Atlanta. In this instance, the defendant remained in the apartment hallway and he refused to leave. He was given a warning by the apartment manager, and alongside he's also asked to leave by the security guards and officers, which he refused. When officers made contact with him, he stated his name was quote John Doe, and at that point when he was almost arrested, he tried to resist arrest. Because of this, the state is recommending a $3,000 surety bond, $1,000 for each count, with the conditions of no alcohol, drugs, and weapons while out on bond, and stay away from the incident location at 1010 West Peachtree Street, Northwest Atlanta. Our main concerns is that he does have that outstanding FTA from Cobb County, which is from June 17, 2021. So this demonstrates that he is a flight risk. Thank you, Your Honor.
All right, I'm going to release him to the FTA, a $500 signature bond through the jail on each count, $1,500 signature bond through the jail total. Stay away from 1010 West Peachtree Street, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Thomas?
It does, Your Honor. However, can he get a one-time escort to get his personal belongings?
Of course, one-time escort with law enforcement to retrieve any belongings from 1010 West Peachtree. Okay, anything further on Mr. Goodman?
Nothing further, Your Honor. Thank you.
He has his hand up, Ms. Thomas.
Mr. Goodman, if you have any questions, please give me a call.
Were you able to speak with the person that was on the lease? Because I have been living there.
I was not.
That's why I have been living in that residence for a couple weeks now.
Right, and Mr. Gilman did not answer the phone.
All right, if you can talk to Ms. Thomas at a later time, Mr. Goodman.
Position 26, Sanchez.
Good afternoon, Mr. Sanchez. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Sanchez, you've been charged in case 22 CR 005050E with driving under the influence of alcohol, concentration of more than 0.08. Driving under the influence of alcohol less safe, improper erratic lane change, and expired or no license on person. Is there a history, Mr. Howard?
Yes. Last arrest was 2019, failure to appear for driving without a valid license. Had a what is this? False report of a government document conviction from 2009. Had a 06 DUI. 2013 out of Tennessee driving without license. That's it. And that was dismissed.
All right, Ms. King.
Yes, Your Honor, on December 18th of 2021, Roswell Police Department responded to a possible serious injury motor vehicle crash that occurred on Nesbitt Ferry Road near Rivermont Parkway. When they arrived on scene, they saw the defendant's 2003 white Chevrolet Tahoe in a ditch upside down. Yes, overturned and came to rest in a ditch upside down. He was coming down Nesbitt Ferry Road and failed to maintain his lane and left the roadway and ultimately ended up in that ditch. They immediately called for an ambulance to come get him, and they took him to the hospital, and it was obvious that he was extremely intoxicated. There was a smell of alcohol, and he was slurring his words as well. This was all captured on body cam. So once the officer noted all of this, they called backup Officer Knoll and actually showed him the footage that they were able to find. The defendant was actually laying on the ground next to the vehicle with a lot of blood on his face and lacerations in his head and his body, but he was alert, conscious, and breathing, which is why they were able to hear some words from him to determine that his words were slurred. When he got to the hospital, they did do a blood draw, which came back as 0.226. He was severely intoxicated at the time of the accident. And when they spoke to him about why he was driving after drinking, he wasn't even clear as to why he was driving. He was saying, "I'm too drunk to effing drive. I don't know who the F made me drive. I don't know who the F let me drive like this." So there's even an admission from the defendant that he was drinking prior to driving, and he was severely confused. As you can see, the defendant has recovered from his injury, but nonetheless, the state is requesting a $10,000 split bond. That's $4,000 surety for the DUI per se, a $4,000 signature for the DUI less safe, and $1,000 on the other two charges: no driving and no drugs, alcohol, or weapons while out on bond.
So this was back in December of last year?
That is correct, Your Honor. It's unclear to me why it took so long. I don't know if he's been in the hospital the whole time recovering from his injuries. It is not clear to me why it's just becoming before Your Honor today. I can try to see what I can find out really quick, but my preliminary search didn't show me anything or any reasoning why.
Okay, thank you, Ms. King. Ms. Kim?
Yes, Your Honor. Mr. Sanchez is 36 years old, and he has been here in Georgia for 25 years. He has 5 minor children that he has been supporting, and one of the 5, 7-year-old daughter, is currently living with him because he has a full custody of her, and he has a family members here in Georgia. He also has an employment. He currently owns his own remodeling construction company for the last 18 years. That's about how long he has been working in the construction industry. He dropped out of 12th grade 3 months before the graduation from high school. However, he says about this incident, he was basically injured too much. He was not conscious at the time. He was not alert. He does not recall saying any words at the time. Indeed, his hat was basically wide open. It was bleeding. He had to get a lot of blood transmission done, and because he flew out of the windshield, he was very, very injured, and he followed up with officers, and nobody told him that he was going to get any citation, not even the warrant. So this is kind of like a shocking thing that happened. Like 8 months later, he finds out this after he gets out of the hospital. So please, we would like to request for signature on bond, and he is recommended by pretrial services for signature on bond as well. Thank you.
Your
Ms.
Honor.
Falk, good afternoon.
Good afternoon, Your Honor. How are you?
I'm doing well.
I can only speak anecdotally to this, so please take it with a grain of salt, but I know that I've had cases in the past involving DUI where if the defendant is seriously injured, what will happen is warrants are taken out and then he is picked up at a later date rather than them essentially sitting on him over at the hospital until he's released. So that has just been through personal experience. I've had cases like this kind of come through the pipeline a couple of months later after the person is out of the hospital, after they've recovered, and then they're picked up on the warrants.
Okay, thank you, Ms. Falk. Anything further, Mr. Sanchez? All right, so for each DUI, it's going to be $1,000 good bond. For the erratic lane change, a $500 good bond. For the no license, a $1,000 good bond. That's for a total of a $3,500 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Sanchez.
Is there no restrictions on his driving, Your Honor?
Thank you, sir.
Not unless a restriction has been placed on by DDS.
Understood. Thank you, Your Honor.
Thank you, sir.
Your Honor.
Judge, what was the total amount?
$3,500 surety.
Thank you.
Your Honor, just to let the court know, I know when it rains, it pours. We have 2 additional cases that need to be addressed. That we do have the defendants.
I reject that, Ms. Falk. No add-ons.
Unfortunately, they have been in custody since late Friday night, so it's now or never for us.
Okay.
So
You're
we
fine,
do
Ms. Falk.
I will put those case numbers in the chat. I already have one. Mr. Jordan is working with me, thankfully, on the other. And so I will be addressing both of those cases.
Okay, thank you, Ms. Falk. We'll get to this when we get to them.
Thank you.
Thank you. Okay, who do we have next?
Position 13, Hall.
Excuse me, Joe, before we start, I can ask a question. I mean, I never caught an
No,
FT.
Mr.
Oh.
Sanchez, you have every right to remain silent, and you may want to talk about the facts later. Give me a call, or I'll give you a call so we can discuss it.
That's about the FTA that I was locked up for. That I don't want them to run. You know what I'm saying?
Mr. Hall, I'll address it if it needs to be addressed, okay? I'm gonna ask you to remain silent, okay, while we go over your case.
Good afternoon, Mr. Hall. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Hall, you've been charged in case 22 CR 005057C with criminal trespass and damage to property. Is there a history, Mr. Howard?
13 total. Last arrest was January, failed to appear, called, got an open possession of a firearm by convicted felon, theft by receiving. It's 21 CP 197237. Open,
Got it. Hold on. What you saying?
open entering auto and theft by receiving. 21 SC 179927. On probation for possession of a firearm by convicted felon. 19 SC 172684. Also on probation and called for 2 counts of theft by receiving, obstruction, entering auto, possession of a firearm by convicted felon, or felony first offender. He just got put on probation for that in June. You want more?
You're good, Mr. Howard. Thank you. Mr. Segura? And Mr. Hall, I'll give you the opportunity to speak with your counsel. You can put your hand down, sir. We see you
You
there.
messed up for me, Hall.
It's just about the FTA.
Okay, hold on, Mr. Hall. Mr. Hall, you have a right to remain silent. Anything you say can be used against you. I'm going to give you the opportunity to speak with Ms. Thomas if you need to. Okay, so, but for now, let Mr. Segura go, and then I'll have your counsel go. And if you still need to speak with her, I'll give you that opportunity, okay? All right, thank you, sir. Mr. Segura?
Now, this case occurred on July the 30th, 2022, at the instant location of 310 Skipper Place, Northwest Atlanta. In this case, police responded to a dispute at the instant location in which they spoke with a Miss Diamond DeHazier. Diamond, common spelling, DeHazier spelled DeHazier, in which Ms. DeHazier stated that she was in a verbal dispute with her boyfriend, who is a defendant at that day. She stated that she wanted the defendant to leave, but the defendant wanted Ms. DeHazier to give him a ride, but Ms. DeHazier refused. At this time, the argument escalated in which the defendant walks out of vehicle, which damaged the passenger side of that vehicle. And at that point, upon contacting the police, the defendant was arrested. Because of this, we're asking for a $3,000 surety bond. No alcohol, drugs, and weapons were out on bond. A stay away from that incident location, and no further contact with Diamond DeHazier. My main concern involves the defendant being a danger to the community and committing crime while he is out on bond. As Petra has noted, he does have those 2 open cases for the effect of receiving stolen property and entering auto 21 SC 179927, in which he had a $20,000 surety bond, $10,000 for each, which is open. And alongside, he also had that February 2nd, 2021, possession of firearm by convict and theft of stolen property felony, 21 CP 197237, which was a spec bond with a 7,500 surety on that possession of the firearm. As Petra has noted, he does have that probation violations in 2019, alongside and 2018. And alongside those had a guilty aggravated battery and aggravated assault in 2017. And simply put, Your Honor, he was arrested every single year since 2015 for some sort of crime. So it's very likely that he will commit some sort of crime while he's out on bond. Thank you, Your Honor.
Ms. Thomas?
Thank you, Your Honor. And first, I'll just go ahead and address the FTA. Mr. Hall did express to me that he was in custody at the time when he was scheduled to go to court. And I believe that was supposed to be cleared up. He was released from custody. The FTA is from January. He wasn't released until February, Your Honor. So he did want me to express that to you. Hopefully that will be cleared up or soon be reflected. But Mr. Hall is 27 years of age. He is a Georgia resident. He's been here all of his life. He does have family residing in Georgia as well. He's a father to a 6-year-old child. He did express that he attended 2 years of college. Mr. Hall is also gainfully employed. He works at Accor, which is a warehouse which he works with steel. He's been employed there for the past 3 to 4 months. Your Honor, however, he did express to me that the finances would be limited. I am asking for a bond reduction, no more than $1,500 if he is not eligible for that signature bond, Your Honor, at this time.
All right, a $1,500 surety bond, no further contact with the alleged victim, stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Hall.
Thank you.
Position 9, Fuller.
And Your Honor, if we could hear position 10 too, I believe,
Yes,
2 cases.
yes, both cases, 9 and 10.
Okay, good afternoon, Mr. Fuller. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? So, did you hear my question, Mr. Fuller?
Yes, sir.
Okay. You've been charged in case 22 CR 005076F with battery and in case 22 CR 005078C with criminal trespass. Is there a history, Mr. Howard?
I've seen about 36 cycles between Ohio, Delaware, and Georgia. Last arrest was January 19th. I'd have done with it for shoplifting. August 2021, shoplifting. 2011, shoplifting. 2010, shoplifting, dismissed. 08, probation. The Ohio arrest was a 1988 arrest. Last arrest out of Delaware, that was in the 90s. Hold on. Yeah, that was in 95. That's it.
Ms. Tortorella?
Yes, Your Honor, for the battery charge, a $4,000 surety bond. This is for position 9. Conditions, no contact with the victim, and his name is Jarrell Dixon. The first name is Jerelle, and the last name is traditional spelling Dixon. To stay away from the location 21 Bell Street in Atlanta. On January 13th, 2022, defendant Reginald Fuller did wait for the victim, Jarrell Dixon, to come out of the bathroom and struck Mr. Dixon in the face with a closed fist, causing bruising to his eye. The offense did occur at the incident location at 21 Bell Street. The defendant was eventually arrested, and these events occurred in Fulton County, Georgia. Your Honor, as you heard from pretrial, this defendant has cycles everywhere, like in 3 different states, 31 cycles alone here in Georgia. He's a multi-state offender. He currently has, it seems like he has an open theft by shoplifting case. He was arrested for theft by shoplifting on January 19th, 2022 by Dunwoody Police Department. And then on August 27th, 2021, theft by shoplifting again out of Alpharetta. Also, Your Honor, he does have an open felony case in this jurisdiction, 21 CP 202591 for theft by shoplifting. It occurred on August 27th, 2021, and he was let go on an unsecured judicial release. Subsequently, Your Honor, he did commit on June 30th, 2022, another offense. I believe this offense is the criminal trespass on, and we're asking for a $2,000 surety bond for that. The conditions is for him to stay away from the incident location at Lenox Square Mall, 3393 Peachtree Road, Northeast in Atlanta. A theft class, no drugs or alcohol, no weapons, and no new violations of Georgia law. The facts of this case are as follows. Defendant on July 30th, 2022, defendant Reginald Fuller knowingly and without authority entered upon Lenox Square Mall, 3393 Peachtree Road Northeast in Atlanta. After receiving prior to such entry notice that such entry was forbidden. Your Honor, through the investigation, the Atlanta Police Department learned the defendant intended to commit shoplifting at the incident location. However, the victim did not want to press charges, and therefore the officer just went forward with that criminal trespass. The defendant was arrested, and these events did occur in Fulton County, Georgia. Again, Your Honor, multi-state offender. He's recently been arrested for a theft by shoplifting. The most recent one was on January 19th, 2022. Again, Your Honor, he has an open felony case, theft by shoplifting. So for that reason, Your Honor, we do feel he's a flight risk. He poses a risk of reoffending. He's a multi-state offender, and we are asking for surety bonds on both cases. $2,000 for the criminal trespass case and a $4,000 surety bond on the battery. Nothing further.
Ms. Thomas?
Thank you, Your Honor. Your Honor, I'm going to be asking for a signature bond on the battery offense day of battery charge, Your Honor, and a bond no more than $500 for the criminal trespass. We are denying the allegations on both, but however, again, if he is not eligible for a signature bond, we'll be asking for a surety bond no more than $500. Mr. Fuller did express to me that he is currently unemployed and he will not be able to make any bond amount. He is 55 years of age. He's been a Georgia resident for the past 33 years. He does have family here residing in the state. Mr. Fuller did complete college, Your Honor, but ultimately Mr. Fuller has no financial means. He does not have anyone that's going to be able to assist him in making bonds. So that's why I am asking for a bond amount no more than $500 on both if he is not eligible for a signature bond.
All right, on the battery charge, it's gonna be $1,000 surety bond, no further contact with Jarrell Dixon, stay away from 21 Bell Street, no drugs, alcohol, or weapons while out on bond. On the criminal trespass, it's gonna be $1,000 signature bond through the jail. Stay away from Lenox Square Mall, no drugs, alcohol, weapons while out on bond. All
Thank
right,
you.
good luck to you, Mr. Fuller.
Next, we have position 19, Hollis.
Good afternoon, Mr. Hollis. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon, Mr. Hollis. You've been charged in case 22 CR 005080G with criminal trespass. Is there a history, Mr. Hollis?
56. Last arrest was March 2020, possession of drug-related objects. That's 21 CR 000252C. Yeah. Got a 2020. He was later convicted for it. I'll say that, the drug-related object. Got another 2020 arrest, possession of crack cocaine, giving false name, possession of drug-related objects. 20 SC 175388. 2019 possession of drug-related objects. 2019 conviction for 2 counts of theft by taking. Another 2019 theft by taking, giving false name, trespass conviction. 2012 forgery, first degree conviction. A couple of parole violations in 2018. 2018, 2 counts of disorderly conduct conviction.
All right, thank you, Mr. Howard. Mr. Segura?
This occurred on July the 30th, 2022 at the Georgia World Congress Center located at 285 Andrew Young International Boulevard, Northwest Atlanta. In this case, police were notified that the defendant was at that location wearing yellow traffic vest and stood at the entrance at the red parking deck at that instant location, in which he was pretending to be a valet for upcoming vehicles and was asking people to pay a certain amount of money for good drive vehicles to park them. Once police made contact with him, they noticed that he was not an employee. He was just wearing some type of getup to get some money, and that in fact he was given a written criminal trespass warning from the World Congress Center Authority, and thus he broke it and was arrested. Because of this, the state is recommending a $2,000 surety bond with the conditions of no alcohol, drugs, and weapons while on bond, and to stay away from the Georgia World Congress Center located at 285 Andrew Young International Boulevard, Northwest Atlanta. My main concerns is that he's a danger to the community because, as we tried to noted, he does have 56 total cycles, and he does have multiple arrests in the last 5 years, as those that open possession and use drug-related objects in 2020. On our side, he was arrested at least 3 times in 2019, 1 for criminal trespass, and there's 2 death by taking cases in which he was guilty. On our side, 2019, he was also at another death by taking arrest and possession of drug-related object. And so as in 2018, another death by taking and a possession of drug-related items twice. So based on his recent years that had multiple arrests, we find that if he's out on bond, he will commit another type of offense. Thank you.
Can you unmute Courtroom 2 for me, please? Mr. Hollis, if I let you out, you understand you can't go back to the Georgia World Congress Center. You understand that?
Yes, Mr. Morrow.
Okay. Thank you, Mr. Hollis. It's going to be $1,000 signature bond through the jail. Stay away from the Georgia World Congress Center, and no drugs, alcohol, or weapons. All right. So I'm going to let you out, but you can't go back there, Mr. Hollis. All right.
I got you, Mr. Morrow.
Okay. Good luck to you, sir. That's fine with you, Ms. Kim?
Yes, Your Honor.
Thank you, sir.
Good afternoon, Your Honor. This is position 14 here in Courtroom 3, Ms. Hampton.
Good afternoon.
Good afternoon, sir.
Good afternoon, sir.
Ms. Hampton, you've been charged in case 22 CR 005059A with battery. Is there a history, Mr. Howard?
No.
Mr. Segura.
This occurred on July the 31st, 2022 at the Chili's Grill and Barn, located at 7800 North Point Parkway, Alpharetta. In this case, police are dispatched to the incident location in reference to a fight in progress in which the defendant followed the victim, a Miss Heidi Sandoval Espinoza. Heidi spelled Heidy, Sandoval spelled Sandoval, Espinoza spelled Espinoza, who is an employee at that restaurant, into a restroom. At that point in the restroom, both the defendant and Ms. Sandoval Espinoza had an argument which escalated, in which the defendant struck Ms. Sandoval Espinoza with a closed fist to the left side of her face, causing a small cut around the eyebrow area. Because of this, the state is recommending a $5,000 surety bond with the conditions of no alcohol, drugs, and weapons, 1-day anger awareness, a stay away from the Chili's Barn Grill, located at 7800 North Point Parkway, Alpharetta, and no further contact with Heidi Sandoval Espinoza. Our main concern is the safety of the victim, as she was an employee at a restaurant, and this whole incident mainly exploded for some reasons which, as of this point in time, we do not know. And because there was in a public place, and this clear violence against a restaurant employee, we're asking for a surety bond. Thank you.
All right, she doesn't have a history. It's a $3,000 signature bond through pretrial, 1-day anger awareness, stay away from the Chili's Bar and Grill, no further contact with Ms. Espinosa, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. But I thought that was actually, that is actually Miss Thomas, but I think.
Yeah, and Miss Hampton actually, they retained private counsel. I believe her mom, Miss Deborah Hampton, was down there and would have made that announcement, but she's being represented. I'm not sure if her attorney is on the line, but they have private counsel.
Okay, so this is Miss Hampton, right?
Correct.
And is anyone on the, did you interview her, Ms. Kim?
I spoke with her, and I spoke with her mom, and they both informed me that they have private counsel.
Okay, well, I don't see private counsel on the line for Ms. Hampton. Do you have, Ms. Thomas, do you have the contact information for the people that you spoke with?
Yes, I do, and I could put that
Okay.
in.
Well, if you wouldn't mind, just, she's gotten a signature bond, so would you just let them know that she has a signature bond?
Yes, I will.
Okay, thank you.
Mhm.
All right, courtroom 3.
She has a visitor. on
Yes,
the
Your
line.
Honor. We have position 17, Ms. Hartley. Her attorney is on the line.
Good afternoon, Mr. Sessions.
Good afternoon, Your Honor.
Good afternoon, Ms. Hartley. I'm Judge Eric Mora. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Judge Morrow.
Thank you. Ms. Hartley, you've been charged in case 22 CR 005069E with driving under the influence of alcohol less safe, driving under the influence of alcohol concentration of 0.08 or greater, an operation without lights required by law. Is there a history? Thank you. Is there a history, Mr. Howard?
No.
Mr. Segura.
This occurred on July the 31st, 2022 at the Medlock Bridge Road, located at Medlock Bridge Parkway, Johns Creek. And this incident also conducted a traffic stop on a 2014 silver Nissan, in which the defendant was stopped because it was around at night at 1:27 a.m., in which the defendant had no headlights or taillights activated during that time. When police made contact with the defendant, there was an odor of alcoholic beverage emanating from inside the vehicle. At that point, the police asked the defendant if she had any alcohol prior to stopping it, and she stated that she did in fact have a Jack and Coke about an hour and a half prior to her driving. At that point, she agreed to participate in a roadside sobriety evaluation in which they resolved that she had 6 out of 6 validated clues in HGN evaluation. And alongside, the police decided to arrest her since they had, based on the following, observed driving violation, the odor of alcohol, and which became stronger when she spoke. The observed HGN clues, the admission of consuming such of a bourbon before driving, and alongside she agreed to have a breath test in which she had a 0.095 grams and a 0.1029 grams. Because of this, the state is recommending a $11,000 split bond, a $5,000 surety bond for the DUI less safe, a $5,000 signature bond for a DUI per se, and a $1,000 surety bond for operating with no lights, where the conditions of the alcohol, drugs, and weapons filed on bond. My main concern is that the defendant will drive again when she is released, as in 2016, she was cited for a following too closely violation, and in 2018 for speeding a 54 on a 45 lane, and in 2021 for seatbelt violations. So because of this, we're asking for this split bond. Thank you.
Thank you. Mr. Sessions?
Your Honor, Ms. Hartley is a graduate of Furman University. She maintains 2 jobs. One is a full-time job that she works through, basically an import-export type of company. The second, she teaches non-English speakers English in the evening time. She has no prior arrests whatsoever. She has family. She resides in Smyrna. Her mother, sister, brother-in-law, cousins, all sorts of family connections here in the city. She's not going anywhere. She's going to resolve this case. I'm really surprised at that recommendation from the state in terms of the amount of the bond. I mean, if those are aggravating factors in terms of those traffic violations, well, we would all be in jail on a bond that's $10,000, $11,000, $12,000 for relatively minor traffic violations. I'm asking for a $2,000 signature bond for her, Your Honor. Well, I've already been retained on the case, and I'll be on the case throughout the entirety of it.
Your Honor, our surety bond is reasonable as she was driving 5 lights in the middle of the night. She was not only a danger to herself, but to those around her. Thank you.
All right, it's going to be a split bond for the less safe DUI, $1,000 good bond. For the second DUI, it's going to be $1,000 SOB through the jail. For the at lights, it's going to be a $500 SOB through the jail. So it makes it a total of $1,000 good bond for the DUI and a $1,500 SOB through the jail for the other 2 charges, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Anything further on Ms. Hartley?
No, sir. Maybe excused today.
Yes. Have a good day.
Thank you, sir.
Good luck to you, Ms. Hartley.
Your Honor, may I have that breakdown again, please?
Yes, $1,000 good bond for the less safe, $1,000 signature bond for the second DUI offense, and a $500 signature bond for the lights offense.
Thank you, sir.
You're welcome.
The SAP reset date.
The SAP reset date is going to be August 16th. Okay.
Next, Your Honor, we have position number 16, Mr. Tremaine Harris.
All right. Good afternoon, Mr. Harris. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon. I'm sorry, what's the first name?
Tremaine.
Tremaine. You have been charged in case 22 CR 005067E with 2 counts of cruelty to children in the 3rd degree and battered family violence. Is there a history, Mr. Howard?
Yeah, this is second arrest. Last was 2014 simple assault and disorderly conduct. They were dismissed.
Mr. Segura?
This occurred on July the 30th, 2022 at 777 Mercer Street, Southeast Atlanta. In this case, police were dispatched to the instant location in reference to a domestic dispute. When police arrived, they made contact with Miss Sophia Holiday. Sophia spelled Sophia, Holiday, common spelling. And she stated that her husband, the defendant, were both in a verbal argument earlier that night. She stated that the defendant took her two children out of bed and put them inside his vehicle. At that point, Miss Holiday stated the defendant took children out of the vehicle and gave them back to Miss Holiday. And while Miss Holiday was holding a small child, the defendant started to argue with her. At that point, it escalated in which the defendant headbutted her in the forehead while she was holding her son in her arms. At that point, she placed her small child onto the ground and tried to act in self-defense against the defendant. At that point, the defendant grabbed her, ripped her shirt, and threw her onto the ground and continuously started to attack her. When police arrived, they saw that she had scrapes and bruises to her right elbow and her right thigh. Alongside, they also observed that she did have her shirt ripped on the left side. At that point, the defendant grabbed both the children, put them into the vehicle, then left the location. The state is recommending a $7,000 surety bond, $5,000 for the family bodily violence, and $1,000 for each count of cruelty to children in the third degree, with the conditions of a one-day anger awareness, no alcohol, drugs, and weapons, a stay found at instant location, no further contact with Sophia Holiday, third-party transfer of children, and a one-time police escort to retrieve belongings. My main concern is about the safety of Miss Holiday, as she stated when we spoke to her this morning, that both she and the defendant are married and live together, and which they have two children. Well, one is 5 and the other one is 3. And she stated she does not want to have any contact with the defendant and is in the process of filing for divorce. Not only that, she said she wants to have third-party transfer of the children and a one-time police escort for the defendant to retrieve his belongings. She stated that the defendant did grab her in the past, but he has never hit her at that point or to that extent. So this shows that in fact the violence escalated to the defendant now attacking Miss Holiday. And not only that, she stated that aside from the scrapes to her, she also had scrapes to her elbow and hip, and also her hip was pulled out from its roots. And she also has bruises on her arms and legs. Thank you, Your Honor.
Thank you, Ms. Thomas.
Thank you, Your Honor. Mr. Harris is strongly denying these allegations. He is 30 years of age. He's been a Georgia resident all of his life. As we heard, he is the proud father of 2 boys, a 5-year-old and a 3-year-old. He and Miss Holiday have been together for the past 15 years and married for 3 years. Mr. Harris is currently in college. He takes online courses at Southern New Hampshire. And Mr. Harris is also gainfully employed. He works with Wells Fargo, where he's been working there for the past 5 years. And he's expected to go back to work on Wednesday. As we heard from pretrial, Your Honor, Mr. Harris barely has any history, specifically no violent history and no convictions, Your Honor. I'm asking the court to take that into consideration. Mr. Harris is fine with moving his belongings. We do ask for a one-time escort to retrieve his remaining belongings. Mr. Harris says he will have his own apartment. We will be asking for a third-party transport and visitation with the children. And I'm sure that they will work out the custody arrangements down the line. But we are asking for third-party and a one-time escort to retrieve any personal belongings. We are asking for a signature bond, given his limited criminal history, no violence, and no convictions, Your Honor. In the chance that he is not eligible for a signature bond, I'm asking for a bond amount no more than $1,000.
All right, for each of the cruelty to children, it's going to be a $500 signature bond through pretrial. For the battery, it's going to be $2,000 signature bond through pretrial, makes it a total of a $3,000 signature bond through pretrial. 1-day anger awareness, no further contact with Ms. Holiday, stay away from the Mercer Street address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. And he can have third-party transfer of the children for visitation, no drugs, no alcohol or weapons while out on bond.
Thank you.
Good luck to you, Mr. Harris.
Thank you.
You're welcome.
7, Cullen.
Good afternoon, Mr. Cullen. You've been charged in case 22 CR 005074H with simple battery. Is there a history, Mr. Howard?
No.
Ms. Tortorella?
I'm sorry, Your Honor, how do you spell the defendant's last name?
Cullen.
I'm sorry, let me look at the calendar.
Oh,
Cullen.
Yes, Your Honor, there are two related cases which the facts would be the same for these cases. It's Miss Curry, who is my client, and also Mr. Cullen is my client as well. And I believe that there's a Mr. Anderson.
That's right, Your Honor, they're cross defendants. There's 3 parties involved in this matter.
Okay, so we've got Mr. Cullen and this Miss Curry, she's on the add-on calendar.
On the add-on, and then Dominique Anderson, position 1 on the normal, on the regular calendar.
And Anderson, okay.
I'm representing Mr. Cullen and Miss Curry.
And Miss Curry.
Yes, Your Honor.
All right, so, and it's Mr. Anderson in courtroom 2?
Yes, Judge.
Okay, so we'll take Mr. Anderson next, if you don't mind, after Mr. Cullen, okay?
No problem.
Thank you. All right, and then we'll have to get to Miss Curry when we get back to wherever she is.
Yes,
Okay?
Your Honor, and I'll be addressing Ms. Curry.
Okay.
Okay,
Let's see. Ms. Tortorella.
yes, Your Honor. So on the facts of the case on July 29th, 2022, Officer Jane Mountain of the Sandy Springs Police Department responded to the incident location at 3706 Sandalwood Drive. For the record, that's S as in Sam, A N as in Nancy, DAL, WOOD as in dog, Drive in Sandy Springs. At the scene, the officer spoke to the cross defendant, Dominic Anderson, defendant Navario Cullen, and cross defendant Zabranique Curry. Ms. Curry and the defendant advised the officer that they were at the incident location when they noticed the cross defendant inside Ms. Curry's car. Ms. Curry walked out and told the cross defendant to get out, Mr. Anderson, to get out of her vehicle, and noticed a bag sitting on the ground with her mail in it. Ms. Curry grabbed the bag and proceeded to walk back into the residence when Mr. Anderson rushed and grabbed the bag. The two began wrestling for the bag, and the defendant noticed a struggle and ran outside to defend Ms. Curry. They wrestled for the bag and then pulled Mr. Anderson inside the incident location. Mr. Anderson then pushed Ms. Curry to the ground and began to fight the defendant. Mr. Anderson then ran out of the residence and called 911. Mr. Anderson said he was sitting outside next to his vehicle when Ms. Curry and the defendant came out of the residence and began arguing with him. Mr. Anderson was holding the bag, and then Ms. Curry grabbed it. The defendant jumped on him, and the two began to strike Mr. Anderson before pulling him inside the residence. The striking continued until Mr. Anderson was able to leave the residence and call 911. An anonymous witness advised the officer he observed all three parties fighting outside before going inside the residence. They heard the fighting continue inside before observing Mr. Anderson run out of the residence. The officer was unable to determine the predominant aggressor, but all three parties were arrested, and these events took place in Fulton County, Georgia. Your Honor, given the fact that this defendant has no criminal history, we are okay with a $3,000 signature bond through pretrial for Mr. Cullen. Conditions is no contact with the parties involved in this matter, and that's Mr. Dominic Anderson and Ms. Zabranique Curry. The first name is spelled Zebra, N as in Nancy, IQUE. Last name is CURRY. For him to stay away from the incident location at 3706 Sandalwood Drive in Sandy Springs. 1 day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Nothing further.
Who is Mr. Cullen to Miss Curry?
Mr. Cullen is Miss Curry's nephew, Your Honor.
Okay, so in the Sandalwood Drive is Miss Curry's
It
residence?
is Miss Curry's home, and I have spoken with her, Your Honor, and she absolutely wants her nephew to live with her. What she wants is a complete no contact with Mr. Anderson, who she describes as a violent and abusive boyfriend of hers that she doesn't want any contact with. But she does want her nephew to continue to live in her home.
And Your Honor, given the fact that there was no predominant aggressor identified, leaving it up to the court to decide as far as the no contact or the stay away. The stay is, I'm sorry.
Okay, so it's going to be a $3,000 signature bond through pretrial. No further contact with Mr. Anderson, and no drugs, alcohol, or weapons while out on bond.
That will be fine, Your Honor. No contact with Mr. Anderson is important. My client doesn't want to have any contact with him.
Okay.
Who is this we're doing?
Okay, this is Cullen that we're on now.
Okay.
Mr. Cullen.
And
No.
Your Honor.
Hold on. Just one moment. Miss Bridgewater's trying to get
Okay,
the
so we're
paperwork
on
correct
Cullen and it's no contact with Mr. Anderson.
with Mr. Anderson. Okay?
Okay, and is he to stay away?
No.
No,
No,
it's no
he's not to
serious.
stay away, okay?
Your Honor, my client is only 8 years old. He is an honor student in high school. He tells me he has 2 jobs. He wants to become an ophthalmologist. This is a good kid who was trying to defend his aunt when she was being attacked by her abuser.
Okay, thank you, Ms. McLeod. Now, Mr. Howard, is this Miss Curry that we have in courtroom 3?
Yes, Your Honor.
All right, is there a history, for Miss Curry, Mr. Howard?
She has 7 adult arrests. Back to Cullen though. Does he need a cosigner? He's still in high school?
He's not in high school. He's graduated. I said
Okay.
he was an honor student. He has graduated.
Okay. Curry, this is her 7th adult arrest. Yeah, I'm gonna defer to you on this one, Judge. Last arrest was 2014 out of Pennsylvania for simple assault. That was dismissed. 2014 DUI, alcohol or controlled substance, that was a conviction. 2010 robbery, possession of a cosmetic drug. Hold on. We got simple assault conviction and theft by unlawful taking conviction, 2010. I'm not sure about that disposition for the robbery. I think the robbery might have been reduced to unlawful theft by taking though.
Okay, thank you, Mr. Howard. So for Miss Curry, it's going to be the same thing, a $3,000 signature bond through pretrial, no further contact with Mr. Anderson, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Okay, so now let's go. So this should be, is this Mr. Anderson?
This is position 1, Mr. Anderson.
I'm sorry, Ms. Falk. Go ahead.
I just wanted to make sure. So that was on Curry as well.
Yes.
Okay.
No, Curry and his aunt can continue to live together. She wants him to live with her. She tells me that her
Ms. McLeod, I'm not confused about the conditions. What I was asking the judge is the bond that he just applied on Curry as well as Cullen? Did he apply the same bond as to both?
Okay, okay. I thought you meant was there a
Nope,
condition?
just trying to get some clarification from the court.
I
Thank you.
understand.
All
Thank
right.
you.
Oh, you on 10 today?
Hold on. Ms. Bridgewater, are you good?
I'm good. Both Curry and Cullen have a $3,000 SOB through pretrial.
Yes.
No
So,
weapons, drugs, or alcohol, and no further contact with Dominique Anderson.
okay, so you got that, Mr. Howard?
Yes. I understand. So are we writing this in or are we gonna get a copy of the calendar?
I got an add-on. Mr. Jordan brought me an add-on calendar. It's Ms. Curry's position number 1 on the add-on calendar.
Thank you.
I don't have an add-on.
Thank you, Mr.
All right.
Okay, so we're done with Ms. Curry and Mr. Cullen. Let's go to Mr. Anderson. Is there a history for Mr. Anderson, Mr. Howard?
Third
Position
arrest.
one. Okay,
His last arrest was 2010 out of Pennsylvania as well. Possession of a cosmetic act, a drug. It was dismissed. He pled guilty to 1 count of it, and then 1 count was dismissed. So that's all he has.
okay, and I've got down that he was recommended also, right? Or not?
Yeah.
Yes, okay.
The whole group.
Anything further, Ms. Tortorella?
Just to point out, Your Honor, this, we're asking for a surety bond, because the defendant is a multi-state offender. He has a history, and he poses a risk of reoffending while out on bond. So for that reason, we're asking for a surety bond on this matter, Your Honor.
Okay, I'm gonna give him a signature bond also. It's gonna be a $2,000 signature bond on each charge, which is a $4,000 signature bond through pretrial. No further contact with Mr. Cullen or Ms. Curry. Stay away from 3706 Sandalwood Drive, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, would
Yes.
he be allowed to, a one-time escort to get any personal belongings? His name is also on the lease.
Okay.
My client is afraid of Mr. Anderson, and apparently he was arrested before for assaulting Mr. Cullen, and he was escorted back to the premises by police officers, and that is when this last incident occurred.
There were police at the scene when this happened?
Apparently the police had been gone 5 minutes. They had taken him there to get his belongings. They had been gone no more than 5 minutes when they saw him in her car.
Okay, so put your hand down, Mr. Anderson, right now. I'll give you a chance to speak. He's gonna come and go. I can't believe that if you get a one-time escort, that they leave somebody there. That makes no sense.
Apparently that's what happened, Your Honor, and that is when this incident occurred.
Oh, I'm not saying that it didn't happen, Ms. McLeod. I'm just saying that that's not, if you get a police escort, the police escort should be there the whole time, and they should escort you away also. So he's to go with police, he's to pick up his belongings, and he is to leave with police. That's my understanding of what a police escort should be.
Yes, Your Honor.
Okay, so he's allowed to do that on one occasion to get any belongings. All right, anything further on Mr. Anderson?
Nothing further, Your Honor. Thank you.
Nothing
was that
further from
total?
the state.
Say it again, Mr. Howard.
What was the total?
4,000, 2,000 on each count.
You doing anger awareness?
No, not on these.
You didn't do for the other 2 as well, right?
I did not.
Okay.
Okay, so, all right, Mr. Anderson. Good luck to you, sir.
Thank you, sir.
It's through pretrial, correct, Judge?
Yes, it is.
Position 6, Mr. Copeland. Thank you.
Good afternoon, Mr. Copeland. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. How you doing too?
I'm doing well. Thank you, Mr. Copeland. You've been charged in case 22 CR 005071E with simple battery family violence. Is there a history?
And Your Honor, I'm sorry, there's also a cross defendant in this case, Moniqua Copeland. So maybe. if
Oh,
we-
okay. She's position number 5. Okay, thank you. Go ahead, Mr. Howard.
It's the 8th arrest for Copeland. Last was 2003, 2 counts of simple battery, dead docket. Before that was 93 simple battery. That's it.
Okay, and what about for Moniqua Copeland? Position 5, Mr. Howard, while we're doing it. Mr. Howard.
He should be in courtroom 3, Judge.
Yes, thank you. Tucson, are you with me? I guess not. I'll come back. So go ahead on position 6, Ms. Tortorella.
Yes, Your Honor. We're asking for a $4,000 surety bond for the simple battery family violence charge. Conditions is that he have no contact with the cross defendant, Moniqua Copeland. First name is spelled Moniqua. The last name is COP as in Peter, ELAN as in Nancy, D. No contact. Well, there's 2 minor victims, but stay away from the location at 2700 Camp Creek Parkway, apartment 21-C in College Park, Georgia. Third-party transfer for the children, 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, on July 31st, 2022, Officer L. Stalling was dispatched to 2700 Camp Creek Parkway in College Park pertaining to a domestic situation. The officer was able to make contact with the cross-defendant Moniqua Copeland, who said her husband, defendant Patrick Copeland, choked her and also hit her in the face. The defendant was detained, searched, and placed inside the officer's patrol vehicle. The defendant then said that while he was using the bathroom, the cross-defendant pushed the door open, and as he was trying to force the door shut for privacy, the cross-defendant prevented him from doing so, which caused the cut on his eye and lip. The cross-defendant advised the officer, Ms. Moniqua Copeland, that at times the defendant would attack her by pulling her hair, choking her, and putting her against the wall. The officer did not see any marks on Ms. Copeland, but did observe her hair was out as if she was tussling. The officer observed 8-year-old JH initials and 3-year-old KB as in boy initials, who saw the fight between the parties take place. Both parties were arrested, and these events occurred in Fulton County, Georgia. Your Honor, this defendant has 8 cycles. He pled to simple battery, though very remote, in Fulton State Court back in 1995. In 2003, he's been arrested for simple battery, which was a dead docket. This was the arrest by APD. In 1988, he was arrested for aggravated assault. Yes, they're very remote, Your Honor, but we are here before this court, again, hearing a violent offense from this defendant. For that reason, based on his history, we're asking for a $4,000 surety bond with the condition stated. Nothing further.
Okay, so you charged Ms. Copeland with 2 counts of cruelty to children, but you didn't. Okay, so she's charged with battery family violence and 2 counts of cruelty to children, and he's charged with simple battery family violence. Is that right?
Correct, Your Honor.
Yes,
All
Your
right.
Honor, and legally we cannot charge
Right,
children in that situation.
I understand, Ms. Falk. Thank you.
Sorry, I just wanted to make sure Ms. Tortorello didn't take the hit for that one.
Oh, yeah, I'm just trying to get it all together myself, so thank you.
And Your Honor, just for the jail to know, the state did not on docket the cruelty to children 3rd-degree charge that he got booked in for.
Quick question, I'm sorry, Judge, it is on his 3 cards, so it's not counted against him, because that charge is on his 3 cards. The cruelty to children for Mr. Copeland?
It is?
Yes, on my 3 card, yes, it is.
Okay, so he has not been accused of that, right,
Okay.
Ms. Tortorello? You are muted, Ms. Tortorello.
Correct. We relayed the document via Odyssey, and we also emailed the jail and CC the public defender's office.
Okay, so Ms. McLeod, you're representing Patrick Copeland. Who's representing?
I am, Your Honor.
And who's representing Moniqua Copeland?
I am, Your Honor. That's my case.
Okay, so there's going to be an issue as to who gets to go back to the 2700 Camp Creek Parkway.
Yes, Your Honor, I would definitely like to address that issue if the court
Okay,
would
so
allow me to.
they've both been recommended. And from what I've heard, they're going to get signature bonds, but I'm concerned about where they're going to go. So I'm going to let Ms. McLeod, you speak as to your client going back to Camp Creek, and Ms. Thomas, if you could speak to your client going back to Camp Creek and where the children are going to be.
Okay, Your Honor, my client, who's 55 years old, any criminal history that he has, the court can see is very, very remote. He has been gainfully employed for the past 16 years with Centus, which shows, some degree of stability. He is a father of 10 adult children and he has 11 grandchildren. 2 of the grandchildren were actually present when this incident happened. My client was very distraught because he said he was using the bathroom, clothes down, pants are down, everything, and his wife kicked the door in and the grandchildren actually saw him naked, which was very distressing for him. And he was just trying to close the door to stop her. Said he never put his hand on her at all, and that her hair was pulled out because she pulled out her hair in the course of trying to undo it, but it was not him that that did it, but she did strike him and she pushed the door open, and his biggest concern was just the fact that the grandchildren were there and saw him with his pants down. That traumatized him. Your Honor, my client tells me that he has nowhere else to go. The grandchildren, incidentally, do not live there. They were just visiting. I believe Mrs. Copeland was babysitting them at the time. He says that she can go and stay with her daughter. She would be able to do that. He has nowhere else to go, Your Honor. So I would ask the court to consider that since they're both on the lease. Thank you, Your Honor. And he does not want any further contact with her because, I believe he says they're about to file for divorce.
Ms. Thomas?
Thank you, Your Honor. When I spoke to Ms. Copeland, she expressed to me that she does not have anywhere to go. They have been living at that residence for the past, I believe, 8 to 9 years. Ms. Copeland works at the Family Dollar where she's been working there for the past month, but she would need financial assistance to go anywhere else. Ms. Copeland also babysits all of her grandchildren. As Ms. McLeod said, she was babysitting 2 of the grandchildren at that time. She's a grandmother, I believe, of 8 or maybe more than 8 grandchildren, which she helps all of her children on the weekends and during school days when their parents are at work. They go over to the grandparents' home so she can watch them. But she expressed that she did not have anywhere else to go. I did speak with Miss Jasmine Copeland, the daughter, who confirmed that as well, as that she helps with the grandchildren at that residence.
And Your Honor, just to remind the court, this happened recently, so there hasn't been any time for cooling off between both parties. We do stress that there be a stay away order for one of them and no contact for the both of them. And also, Your Honor, just as far as Ms. Copeland, she did plead guilty to reckless conduct last year in Fulton County.
And Your Honor, I would just like to point out that he was the one sitting on the stool when she started this, and I feel like she was a primary aggressor and he should not be punished because of her aggression.
And Your Honor, obviously we will deny being the primary aggressor and reserve all arguments from which we actually receive the discovery and actually go forward with trial. But at this time, we deny these allegations.
Okay, so I'm just trying to, and I agree with Ms. Tortorello, and I think that your clients agree too that there not going to be any further contact. So if there's not any further contact, somebody's going to have to go somewhere. Mm-hmm. So is there...
She babysits all those children for her daughters, so I think one of the daughters could accommodate her.
And if Mr. Copeland has 10 children, I believe any one of his adult children might be able to accommodate him as well. She babysits children for all of her adult kids.
So therefore, the adult kids can help her out. She can stay with one of them.
Or him.
Okay, Ms. Thomas, your client has her hand up.
Yes, Ms. Copeland. Do you have somewhere else you may be able to stay?
No, I don't. And
okay, I'm gonna just have you limit your response to that question. Okay, if you have anywhere else to stay, can you stay with any of your adult children?
No, I don't. Only 2 have their own places, and they have their kids. They don't have any room there for me to stay there.
Okay.
Like she stayed, he's been on his job.
All right, Ms. Copeland. I'll just stop you there.
Oh, okay.
Your Honor, and just to, I don't know if this may help the court out. Ms. Copeland has 7 cycles on her history, and Mr. Copeland has it's right here, 8 cycles. So I'm not sure if that may.
Is anything against my client is very remote. The most recent thing I heard was 2003. That's an adult lifetime ago. My client, he is focused and getting on with his life. He's working. This was clearly a situation where she was the aggressor. The facts, as alleged by the police officer, shows that she was the aggressor. If you attack someone when they're using the toilet.
Okay, Ms. McLeod, I appreciate your zeal. I'm just trying to figure out where who's gonna go where. And someone's gonna have to go somewhere. Everybody agrees on that. So for Patrick Copeland, it's gonna be a $3,000 signature bond through pretrial, 1-day anger awareness, no further contact with Moniqua Copeland, and no drugs, alcohol, weapons while out on bond. For Moniqua Copeland, it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further contact with Mr. Patrick Copeland, stay away from the 2700 Camp Creek Parkway address. She can go back to that address on 1 occasion with law enforcement to retrieve any belongings that she might have there, and no drugs, alcohol, or weapons while out on bond. Okay, so good luck to you both, you, Ms. Copeland, and you also, Mr. Copeland.
Your Honor, hold on, please. Your Honor, for Ms. Copeland, is 1515?
It's thank you. I'm sorry, Officer Milson. It's 2,000 for the battery, 500 for each of the cruelty to children, which makes it a total of 3,000.
Okay.
Okay.
Could I say something?
Ms. Copeland, you have the right to remain silent. Anything you say can be used against you. I'll advise that you need to talk with Ms. Thomas at some point after this hearing today. Okay, ma'am?
You're done.
Okay. All right. Who do we have next?
Position 3, Mr. Beatty. I wasn't.
And this is position 3, is that right?
Yes, Judge, position 3, Mr. Beatty.
Thank you. Mr. Beatty, good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Go ahead, say it again, I'm sorry.
Yes, sir. Good afternoon, you too.
Okay, thank you, Mr. Beatty. You've been charged in case 22 CR 005058G with criminal trespass, 2 counts. Is there a history, Mr. Howard?
His 9th arrest. Last was 2018 suspended license, given false name. Another 2018 suspended license. As far as violence, he had a 2011 ag assault. It was indicted, then amended to simple assault conviction out of DeKalb County. That's it.
Ms. Tortorella?
Yes, Your Honor. For the criminal trespass damage to property charge, it's a $1,000 surety bond. For the criminal trespass charge, the second charge is $500 surety bond. That's a total of $1,500, and that would be a good bond. Conditions is no contact with the victim, Tiana McGahee, and the first name is spelled Tiyan as in Nancy, N as in Nancy A. The last name is McGahey. To stay away from 988 Trestle Tree Court Southeast in Atlanta. No drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, we've had contact with the victim. She states she doesn't fear the defendant. She states that they're in a relationship and they live together and have 2 children. This is very concerning for the court, as the victim actually has a prior open case where she's the defendant and the defendant is the victim. So therefore, the parties have prior difficulties. This case number is 22 CR 001410, I believe it's J. This offense occurred on March 15, 2022, where Ms. McCahey caused visible injuries to the defendant, including swelling, bleeding, and scratches by striking him. Ms. McCahey was granted a $2,000 signature bond through pretrial by Your Honor, where she was ordered to have no further contact with this defendant before us today, and third-party transfer of the children. It seems like these two parties are still having contact, Your Honor, as on July 31st, 2022, at the incident location, defendant Demetrius Speedy intentionally caused damage to a window in the rear of Ms. McCahey's residence. Ms. McCahey is the mother of the defendant's children. The defendant threw a rock through a window after being advised by Ms. McCahey to leave the premises. The damage to the window is less than $500. These events occurred in Fulton County, Georgia. Again, there are 9 cycles. He poses the risk of reoffending, intimidating the witness here and victim. These parties are not supposed to have any contact, Your Honor, and they're still having contact. It's clear that they cannot have contact, as each of them have a case against the other. One has battery, family violence. This is a criminal trespass. However, you could consider it violent as an object was thrown through a window at Ms. McCahey's residence. For that reason, we're asking for the $1,500 surety bond, which, Your Honor, I believe it's more than reasonable given these parties' histories, and no contact, stay away, and the other conditions already stated.
Mr. Beatty, keep your hand down. You have a right to remain silent. Please exercise that right. I will speak for you.
Okay, so Ms. McCahey has a no further contact with Mr. Beatty.
Correct.
Until today, well, Mr. Beatty didn't have a no further contact. He had no onus on him.
Correct.
This is correct.
Okay. All right. So, but now he is going to have an onus on him because he's not going to have any further contact with Ms. McCahey. So it's going to be $1,500 signature bond through the jail, $1,000 for the criminal trespass. I've just got 2 criminal trespasses, but apparently one is criminal trespass damage to property. That's going to have $1,000 signature bond through the jail. The other criminal trespass is going to have a $500 signature bond through the jail. No further contact with Ms. McCahey. You want to speak to if she wasn't, do they live together, Ms. McLeod?
No, yes, at one point they were living together, but I've spoken to my client about that, and he tells me that he's going to go and live with his brother. They do share an 8-year-old, a 3-year-old, and there is a child on the way, apparently, Your Honor. But he says he has spoken to his brother, and his brother has already agreed to do any kind of interaction with respect to the children, and he will be living with his brother. He probably does need the one-time escort, Your Honor.
And Your Honor, he probably does need that one-time escort because the victim has told us they are living together currently.
Right, that's what he says that too, but he did say he has somewhere else to go. He admits that they have been living together.
Okay, so
I was not aware that there was a stairway, Your Honor, and my client did not communicate that part of it to me, but he did tell me he will be living going forward with his brother.
Okay, so
and he doesn't need contact with her, only the children. He would like to see the children, and his brother would facilitate that.
Okay, so stay away from the Trussell Tree court address. You can go back there on one occasion with law enforcement to retrieve any belongings. It'll be third-party transfer of the children, and no drugs, alcohol, or weapons while out on bond. Let me speak to Mr. Beatty for a moment. If you can, Mr. Beatty, just so that I make it clear, Ms. McCahey had a no further contact with you. Apparently, she is in violation of that based on what's been said today. She could go back to jail. Her bond could be revoked, and she could go back to jail. All right, so that's on her. But what's on you is that you're not to have any further contact with Ms. McCahey. And I want to make clear what no further contact is. It's no personal contact, no phone contact, no email contact, no social media contact, no contact whatsoever until this matter is resolved. I'm not going to keep you from your children, so you can have third-party transfer of those, but if you allow Ms. McGahee to have contact with you, you both can be in violation of your bonds, and they could both be revoked, and you could both be back here. You understand what I'm saying?
Yes, sir.
All right, so I don't want to see that to happen to either one of you. All right, so good luck to you, Mr. Beatty.
Thank you very much.
What's the total?
What's that?
What's the total again?
1,500.
And the not criminal damage, but the criminal trespass damage to property is count 1, Your Honor.
Okay, thank you.
I showed 2 criminal trespass.
Yes, that's why I clarified it. The criminal trespass damage to property is count 1, and the criminal trespass, because he was advised to get it off of the property, is count 2.
Okay, thank you. Next, we have position 11, Mr. Gilmore.
Good afternoon, Mr. Gilmore. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Thank you. Good afternoon, sir. Mr. Gilmore, you've been charged in case 22 CR 005052F with theft of service and possession of marijuana less than an ounce. Is there a history, Mr. Howard?
This is 4th arrest. Last was August 2021 out of Jackson, Mississippi for domestic violence. July 2020, it says operation of vehicle without payment of tax. Suspended license and controlled substance violation. 2019, simple domestic violence. And he's a resident of Jackson, Mississippi.
All right. Mrs. Severa.
This came back on July the 30th to July 35th, 2022 at the Aloft Alpharetta, which is an apartment complex, which is a hotel residence located at 7895 North Point Parkway, Alpharetta. Also was dispatched to the incident location, in which the manager of that Aloft Alpharetta hotel stated that a member got a call. A member called them about his credit card being charged for 2 nights at that hotel. When police checked the name of who actually checked in the hotel, they found out it was a defendant. And police confronted the defendant. He stated that his uncle, Mr. David Johnson, was the one who booked it for him. And outside, the defendant called his uncle other names such as David Lee and Lee Johnson. And at that point, he said he sent money to pay his uncle for the room. But when police saw his receipt, it was to Mr. Jacob Johnson, which was the name matched the credit card holder. At that point, another companion who was with the defendant, and Ms. Victoria Ward, stated that there was no collaboration for the defendant's claims, and the member whose credit card was lost stated that he lost a credit card the month before in North Carolina. And police found out the charge amount for the hotel for the 2 nights was $271.60. And in that vehicle the defendant was in, they found there was a small pre-rolled blunt, which the defendant said was his. Because of this, we're asking for a surety bond of $2,500, $2,000 for the theft of service, and $500 for the possession of marijuana, with the conditions of no alcohol, drugs, and weapons while out on bond, and a stay away from the Aloft Alpharetta, located at 7895 North Point Parkway, Alpharetta. My main concern is that the defendant is a Mississippi resident. As pretrial notice, his most recent crime was for simple domestic violence in 2021, and thus this shows a lack of community ties. Alongside, the defendant has an outstanding warrant for an FTA from March the 5th, 2022 from Brazelton, Georgia, which shows he is a flight risk. Thank you, Your Honor.
Mr. Segura, let me get this straight. So there was a, does he know the person's whose credit card that was allegedly used?
Based on the warrant, he doesn't. He just used someone else's credit card who he does not know to book those two night stays at that hotel.
Okay, so he's not charged with anything regarding that credit card. He's charged with not paying for The rooms.
Yes.
Okay. All right, Miss Falk.
If I can just offer some assistance, Your Honor, the reason he wasn't charged under 16-931 for financial transaction card fraud is because the card actually wasn't used. It was the Marriott Bonvoy account information. So it was done through his rewards account, and that's how the room was booked. So they weren't able to trace it to an actual physical card. And so that's why they couldn't do a financial transaction card or theft or fraud.
Okay, thank you, Ms. Falk. I appreciate it.
Thank you, Your Honor.
Ms. Thomas.
Thank you, Your Honor. Mr. Gilmore is 29 years of age. He is a Mississippi resident. He was up here visiting. He did express that he does not have any family and friends here. However, he did graduate from high school. He's also gainfully employed. He works at Express Employment, where he works as a warehouse laborer, and he also does landscaping. He's been doing so for the past 6 months, Your Honor. We're going to ask for the bonds to be reduced to no more than $1,000. If Mr. Gilmore is not eligible for a signature bond at this time, giving his limited resources and he's been only working at his job for the past 6 months. We were unaware about any warrant or hold from Mr. Gilmore. When I checked, it didn't show that he had a warrant hold, so that is new information to us. So I would be asking for a signature bond to be released to said hold. I'm not sure what county or where we're at. Did I hear the state say somewhere in Georgia?
Yes.
Brazelton. I don't know what county that is though.
Okay. Well, we would ask for a signature bond to be released to Brazelton, Georgia, Your Honor, or if he's not eligible for a signature bond, a bond no more than $1,000.
Okay, it's going to be a split bond, $1,000 good for the theft of service, a $500 signature bond through the jail for the marijuana. Stay away from the 7895 North Point Parkway location. No drugs, alcohol, or weapons while out on bond. Okay.
Thank you, Your Honor.
Thank you.
Thank you, Judge. We're completed here in courtroom 2.
Okay, thank you. We appreciate it. See you tomorrow.
Thank you.
So we're going to courtroom 3.
Yes.
Yes, Your Honor. Position number 4, Ms. Brockett.
Okay, give the court about 2 minutes. I'll be right back with you.
Yes, Your Honor.
Yeah, what happened with Ricky Love?
I'm not sure. I don't know who that is. I didn't interview him.
Hey, Tucson, Ricky Love is gonna be a medical reset.
Thank you, sir.
Yes, sir.
Just out of curiosity, are there any other medical resets?
That's the only one I have, just Ricky Love.
Thank you, courtroom 2.
Not a problem.
Okay, we're ready to proceed.
Before you is position number 4, Ms. Brockett.
Good afternoon, Ms. Brockett. I'm Judge Eric Moore. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Brockett, you've been charged in case 22 CR 005060Y with battery family violence. Is there a history, Mr. Howland?
A fifth arrest. Last was December 2021 for trespass. On probation and called for burglary. October 2018, they gave us 6 months to serve, followed by 4 years, 6 months probation. Also for theft by receiving, they called probation for that. I don't think she had any violence. Let me see. Burglary. 2018 failed to appear. And the 2021 trespass. That's it.
Ms. Tortorella?
Yes, Your Honor. For the battery family violence, a $4,500 surety bond. The conditions is that she have no contact with the victim, Brianna Haley. The first name is spelled B as in boy, R-E-N as in Nancy, apostrophe Y-A-N-N-A. And the last name is Haley, H-A-I-L-E-Y. To stay away from 550 Abernathy Road, apartment 757 in Atlanta. 1 day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this defendant has an open case, 21 CR 007799 F as in Frank. The offense date December 4th, 2021, filed the same day. She was granted a $1,000 surety bond by Judge Mincy, where she was ordered to not violate any laws or ordinances of the state. She is currently in violation of this bond order due to this offense. She failed to appear on April 19th, 2022 to her arraignment on this case, Your Honor, and appeared to her bond forfeiture hearing where she waived the arraignment and the bench warrant was set aside. This is an indication of flight risk, Your Honor. She FTA'd on a current open case, and as you heard from pretrial, she's FTA'd in 2018 out of Cobb County. Your Honor, on July 30th, 2022, Officer B. Laura of the Sandy Springs Police Department was dispatched to the incident location at 550 Abernathy Road in Atlanta. Upon arrival, the officer made contact with the defendant, Dana Brockett, who advised that she and her girlfriend, the victim, Brianna Haley, got into an argument, but that Ms. Haley called the police. Ms. Haley made contact with the officer, and the officer observed 3 fresh scratch marks on her face. Ms. Haley said the argument did turn physical. Ms. Haley was out on the porch and attempted to go back into her apartment when the defendant stopped her, scratching her in the face in the process. The defendant was arrested, and these events occurred in Fulton County, Georgia. We've had contact with the victim. The victim and the defendant are in a relationship. They live together. The victim, however, has stated she has moved out of the residence and is no longer staying there. So I would I guess she can have a one-time escort, Your Honor, just to make sure the victim's no longer there. And if she's no longer there, the state recommends that she can stay at that location. The victim further stated, Your Honor, that she wants no contact with the defendant. She stated that the defendant has never been physical with her before, but her family has assaulted her in the past. Nothing further from the state.
Thank you, Ms. Thomas.
Thank you, Your Honor. When I spoke to Ms. Haley prior to court, maybe an hour or so, she did indicate to me that she wanted contact. Ms. Haley expressed that she's been living with her mom, that is Ms. Brockett's residence at the Abernathy Road apartment address. She said that she does not fear Ms. Brockett. She says that she wants Ms. Brockett to be let out. And she says that her and her family, Ms. Haley said that her and her family have been trying to and will be helping Ms. Brockett to get out of custody if she's giving a bond. Ms. Brockett does deny these allegations. She is 23 years of age. That is her residence. Again, Your Honor, she's been living there for a year. Her name is on the lease and the utilities. Her and Ms. Haley had been in a relationship for the past 4 years. Ms. Brockett is a Georgia resident. She's been living here all of her life. All of her family lives here. She is a proud mother of a 5-year-old son who is currently with her grandmother as while she's here taking care of matters. She's completed high school, and she's also gainfully employed at the Taco Bell where she has been working, Your Honor. I am asking for a signature bond on her behalf, and if Ms. Brock is not eligible for a signature bond, I am asking for a bond amount no more than $1,500, Your Honor, so that Ms. Brockett can be able to get out of custody and return back to work, and most importantly, her 5-year-old son.
And Your Honor, it appears there's conflicting statements. The victim did speak to our victim advocate. She said she didn't want contact. She said she was moving out. Now the victim has spoken to defense, saying the opposite. This is very clear, Your Honor, that the victim does not know what she wants to do, and it's evident of the cycles of violence, Your Honor. For that reason, we are asking for that stay away. No contact, and for her to have the one-time escort to assure the victim is no longer there. If the victim is there, she shall not return to the address. That's what the state is asking, Your Honor.
And Your Honor, I don't know where the state is pulling the cycles of violence. My client hasn't been convicted of any violent offenses in the past, Your Honor. And as from the state's own statements, the alleged victim told them that she would be living with her mother or out of my client's residence. And that is also what she essentially told me, is that she's been living with her mom. So it is clear that Ms. Brockett will be staying alone. That is her residence. I'm asking that she be allowed to return to her residence, Your Honor.
All right, so it's going to be $1,000 good bond, no further contact with Ms. Haley, no drugs, alcohol, or weapons while out on bond. It goes without saying that if there's no further contact in order, that if Ms. Haley is at the Abernathy Road address, then Ms. Brockett necessarily can't be there. All right, good luck to you, Ms. Brockett.
Thank you.
Next, we have position number 2, Ms. Adiaki. I'm sorry, I apologize for messing up your name.
And this was a cross defendant with position number 25.
Yes.
Mr. Pierre.
Yes, Your Honor.
And let's see. All right. I believe I remember the facts, but Mr. Howard, is there a history?
First arrest, resident of Florida as well.
Okay. Good afternoon, thank you. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 005055D with battery and simple battery. Ms. Tortorello, would you like to briefly refresh the facts? What happened at 265 Peachtree Street?
Yes, Your Honor. This occurred at a hotel on July 31st, 2022. Apparently, both parties that date were on a vehicle. Miss Anya Dyke, the defendant states that while inside the vehicle, the cross defendant, Mr. Pierre, struck her on the side of her neck, the left side of her neck. Mr. Pierre admitted to the police officer that he did hit her, but in self-defense. The cross defendant advised that once they were inside a hotel room, she became violent towards him, and he did sustain minor scratches. She wasn't allowing him to leave the room, according to Pierre. And that's basically what occurred, Your Honor, on this date. We're asking for a $3,000 surety bond on the battery, for the simple battery, a $2,000 surety bond. That will be a total of $5,000 in surety. No contact with the cross defendant, to stay away from the Hyatt Regency Hotel, 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. I understand Your Honor may give a signature bond, but we do have concerns that she is a flight risk, just like the cross defendant. They do not live in Georgia. They were here on vacation, as you heard from Mr. Pierre's defense attorney. And they have no ties to the state, Your Honor.
Okay, I'm gonna do the same as I did for Mr. Pierre. For the batters, a $2,000 signature bond through the jail. For the simple batters, $1,000 signature bond through the jail, making it a total of a $3,000 signature bond through the jail. No further contact with Jerry Pierre. Stay away from the Hyatt Regency at 265 Peachtree Street. She still has belongings there, she can go back on one occasion with law enforcement to retrieve any belongings that she might have there. No drugs, alcohol, or weapons while out on bond. Does that suit counsel?
Yes, Your Honor, thank you.
All right, good luck to you, ma'am.
Your Honor, the parties do have a small child.
Third
And
party.
I'm involved.
Okay, thank you, Ms. McLeod. There'll be third-party transfer of the minor child. Okay, thank you.
Thank you.
Next, we have position 15, Ms. Harris.
Good afternoon, Ms. Harris. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Is that a yes?
Yes.
Thank you. You've been charged in case 22 CR 005068B with simple battery. Is there a history, Mr. Howard?
No.
Mr. Segura?
This occurred yesterday, July the 31st, 2022, at the Harvest Oaks Apartments located at 2980 Delmore Lane, Northwest Atlanta. In this incident, the defendant was walking down some stairs, and when she struck the victim, Miss Teknessa Rowe, Teknessa spelled D-E-K-N-E-S-S-A-H, Rowe, R-O-W-E, in the face with her fist once. Because of this, the state is recommending a $3,000 surety bond, 1-day anger awareness, no alcohol, drugs, and weapons, a stay from the incident location, and no further contact with Teknessa Rowe. Based on the warrant, we don't have much information about this case, so we weren't able to make contact with Ms. Rowe this morning. So because of this, we all strongly recommended to stay away and no further contact. Thank you.
Ms. McLeod?
Yes, Your Honor. My client is 19 years old. As pretrial has pointed out, she has no history at all. She tells me that she should have started a job this morning at Georgia Tech. She would be working there. She's currently working on her GED. She lives at this complex with her mother and her sister. She tells me that the alleged victim was actually the aggressor. What happened was that she saw the alleged victim attacking her younger sister, who is much smaller than this person, and she was striking her younger sister, and she just went in there to stop the victim from hurting her sister, and this is why she was arrested. Your Honor, she tells me that the victim does not live in this complex. This is the home where she lives with her mom and her sister, and the Miss Rowe apparently was just there for whatever reason, but she does not live in that complex. Asking my client to stay away from her home under these circumstances seem unnecessary because Miss Rowe, the alleged victim, does not live there. Thank you, Your Honor.
I'm honest, since we're unable to make contact with Mr. Rowe, we're not too sure where or not she actually lives though. So could we make it conditional that if Ms. Rowe does live there to be a stay away, and if there isn't, then we can take that condition off?
Well, I don't know how you make sure Ms. Rowe doesn't stay in an apartment complex. So, but she's not going to be able to be around Ms. Rowe. So that necessarily means that that she can have no contact. I'm not going to make her stay away from her home. So it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. Rowe, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Harris.
Next, we have position 20, Ms. April Jones. Come on, Ms. Jones, have a seat right here, please.
Good Good afternoon, Ms. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Jones, you've been charged in case 22 CR 005045C with simple battery, public drunk, and criminal trespass. Is there a history, Mr. Howard?
All right, this is a 9th arrest. This is an 8th arrest, I'm sorry. She was arrested in March for reckless conduct and trespass. I think you signed off on her getting time served in SAP. That was on MARTA. 2015 probation violation. 2014 failure to appear. That was dismissed. Possession of a Schedule II controlled substance conviction. 2014. Trespass conviction from 2014. And disorderly conduct conviction. 2009. So I do want to recommend to do to that history.
Okay, Ms. King?
Yes, Your Honor. Her two last criminal trespass convictions were pleas, one in March and one in July. And they were from the same location, the same 5 Points MARTA station, and you gave a stay away in both of the, well, I'm not sure if you did the one in July. I could look real quick if you would like for me to. But the one in March, for sure, there was a stay away in that plea, Your Honor. So she went back again and she was drunk this time. And unfortunately, she spit on a MARTA employee, and the employee, Miss Kendria Cooper, stated that the spit landed on her arm. And she also said that she was intoxicated, swaying back and forth in the station and smelled strongly of alcohol. She was also using vulgar and profane language while in the station. The state is requesting a 7,000 surety. That's 3,000 for the simple battery, 3,000 for the criminal trespass due to her violating her probation conditions, and 1,000 for the public drunk. Stay away from the 5 Points MARTA station located at 30 Alabama Street, and no further contact with Kendria Cooper, Kendria, last name traditional spelling, and no drugs, alcohol, or weapons while out on bond.
Thank you. Ms. Kim?
Yes, Your Honor. Miss April Jones, she is 36 years old, and she was born and raised here in Georgia. And last 3 years, ever since she had a serious car accident, she was hit by a truck, she has been disabled, and the life has been very, very difficult for her. She graduated from high school, and at this point, she has been homeless, and she does also need a wheelchair to walk, because walking without anything is still challenging right now. And we would like to request for signature on bond while, or if Your Honor is not inclined to give her a signature on bond, we would like to request for $250 surety bond, even that she may not be able to pay for. Meanwhile, I would like to request for Social Security services along with BHET, Your Honor. Thank you.
Your Honor, I looked it up. You did give the one in March, and it was Judge Law, the one in July.
Okay, thank you, Ms. King. It's going to be a $500 good bond on each charge, so it makes it a total of a $1,500 good bond. Stay away from MARTA at 5 Points. No further contact with Ms. Cooper. Social worker visit. Also, Ms. Kim, and no drugs, alcohol, or weapons while out on bond. If she doesn't get out, I'll see her on August 16th at the SAP ground.
And that was good bond, Your Honor?
Yes.
Thank you, Your Honor.
Next, we have this. I'm sorry, go ahead.
Your Honor, just to clarify, those other two cases, are they still open, April Jones's other two cases?
Ms.
No,
King?
they
The
were
last one I gave, she got time served on.
correct
Okay.
on both.
I just wanted to make sure any open cases would go as well. So that's
Okay.
why I was checking. Thank you.
Okay, thank you, Ms. Falk. All right, who else do we have?
Add on to Ms. Diaz. Have a seat, please. Thank you.
Good afternoon, Ms. Diaz. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Diaz, you've been charged in case 22 CR 005103B with simple battery. Is there a history, Mr. Howard?
Fourth arrest. Last was 2013, simple assault. It was dismissed. Before that was another 2013 simple assault / domestic assault. Says prosecution declined. That was out of DC, Virginia area. And a 2009 DUI conviction.
Okay, Ms. Paul.
Yes, Your Honor. This incident happened on July 29th at around 7:30 p.m. The incident occurred at 2505 Summer Lake Drive, Sandy Springs, Georgia, and involved the victim, Mr. Walter Lee. So officers arrived at that location, and the caller, Mr. Lee, stating he was having an issue with the roommate, and I misspoke. Miss Diaz is actually the one who called and stated she was having an issue with her roommate. Upon arrival, they did meet with Mr. Lee and the defendant. Mr. Lee stated that Miss Diaz had come into his room, grabbed his bucket of baseballs during an argument regarding bills, and then slapped him twice. He stated he then went back. He followed her to the door of the apartment, which is where she slapped him. When he went back into the apartment, she grabbed his glasses off his face. And then at that point, he pushed her away. The defendant stated that this was her former boyfriend. He was not paying a portion of his rent. And she stated he followed her and cornered her when they were in an argument. She did admit to striking him. She did state that at the time she struck him, he then shoved her. And the officer then asked if this happened after she grabbed his glasses off his face, and she did respond yes. So based on her admission combined with the statements made by Mr. Lee, the defendant was arrested. We are asking for a $2,500 surety bond, no further contact with Mr. Lee, and stay away from the address at 2505 Summer Lake Drive in Sandy Springs. Although Mr. Lee does not object to contact with the defendant, we do have some concerns since there was a former intimate relationship here. Although it is now a roommate situation, there was some issues regarding the fact that they were in a physical relationship prior to this, and that coupled with her admission to striking him and grabbing the glasses off his face during an argument, we do have some concerns. We are asking also for no alcohol, drugs, and weapons, and finally a one-day anger awareness course. This is also based on, and although it's slightly remote, that 2013, those two arrests in 2013 for domestic disputes that resulted in her putting her hands on someone else. Even though they were dismissed, that does cause the state some concern.
Thank you. Ms. Kim?
Yes, Your Honor. Miss Hani Diaz, she is 33 years old, and she completely denies the allegation. She was actually defending herself. All the things were happening out of self-defense. She was not the first aggressor. It was Mr. Lee who was pushing her to the corner, and it was kind of scary. Not only that, the very reason that they broke up was because Mr. Lee wanted to be violent with her child. They don't have a children together. However, she has a child who is 5 years old, who has autism, and he needs special attention and more care. However, Mr. Lee does not understand the difficulties of autism, so he chose to discipline him physically with a corporate punishment, and that kind of caused a lot of tension among them. So that's why those two decided to break up, and they have been broken up about 2 months. And however, their names are both on the lease, and my client strongly prefers to stay in that location since Mr. Lee, either she has to file an eviction to kick him out, or for failure to make a payment for the half of the rent, or he can find another place. The very reason that she needs that location is because of the special school that her son will be going from today. for the autism. They have a special needs education there, and it's kind of hard to find a place where they provide such a needs to the child. So she has 4 jobs. Actually, she's a cosmetology licensed hairstylist. She has a small business for bridal wedding planning business. Not only that, she also babysits at night to pay for her son and herself. She has been very responsible for the last 10 years. And also she graduated from high school and she has 3 years of college education. We would like to request for signature on bond as pretrial services also recommended, Your Honor. Thank you.
Well, I'm not going to put them back together, Ms. Kim. So unless she evicts him, she's going to have to find someplace else to go. So you have anything further, Ms. Falk?
No, Your Honor, just with the amount of time they have lived together and the fact that they're both on the lease, it would have to be a formal eviction process. I just want to make that very clear, not, you know, a do-it-yourself eviction process
right,
as most
yeah,
people tend to engage in.
Right, you have to do it appropriately, properly. It's going to be a $2,000 signature bond through pretrial, 1-day anger awareness, no further contact with Walter Lee. Stay away from the 2505 Summer Lake Drive address. You can go back to that address on one occasion to get any belongings that she might have there. No drugs, alcohol, or weapons while out on bond.
If he voluntarily leaves the place, can she return home if he's not there?
Well, if he's not there, of course, she can go back to the home, or she properly evicts him, she can go back, but
yes.
She can't go back if he's there.
Okay.
The state would just ask if there is going to be a clause that she can return to the address if the defendant, if Mr. Lee is no longer at the address, that there be a police escort just to ensure that Mr. Lee has vacated the premises. I just don't want to run into any situation. And I just received some information from our victim advocate that stated that Mr. Lee is not leaving that location.
Okay, so so she's gonna have to, she can have a one-time escort.
Sure.
Either to pick up her belongings, if Mr., well, I mean, let's just say to pick up her belongings at this point in time, if he's not, because, I mean, he might be at work or something and she's not, you know, when she goes, so, and then he'll come back, so unless she evicts him, then she can't go.
Yes.
She can't go back there.
Definitely she has to take her son, Your Honor, so yes.
Okay, all right. Good luck to you, Ms. Diaz.
Thank you. Thank you.
Okay, is that it?
All right. Yes, Your Honor.
All right, so I guess we'll see you maybe tomorrow. I'm not used to seeing you in Courtroom 3. I'm used to seeing you at the South Annex. What's going on?
I'm visiting.
Okay. All right, we'll see you next time.
Everybody. Take care, bye-bye.
All right. I believe that completes the calendar. Did you all get the note that on one of the positions, it's a position 22, a medical reset, and that's going to be reset for tomorrow, 8/2 on Ricky Love, position number 22.
Yes, Your Honor.
Okay, so when Ms. Bridgewater is ready, she'll go through the calendar.
Okay, I'm ready. Good afternoon, everyone. The reset date for the SAP calendar, again, is going to be August the 16th. Position number 2 is reset further notice with a $4,000 total SOB through pretrial. Position 2 is reset further notice with a $3,000 SOB through pretrial. Position 3 is reset further notice with a $1,500 total SOB through the jail. And the
Hey, hold on. Which one you on? You doing the very first one or not the add-on?
yes, the main calendar.
Okay, can you start from the top again? I'm sorry. What was number 1?
Number 1 was reset further notice with a $4,000 total SOB through pretrial.
Okay.
Position 2 reset further notice with a $3,000 SOB through the jail. Position 3 is reset further notice with a $1,500 total SOB through the jail. And that first charge is a criminal trespass to property. Position number 4 is going to the SAP calendar with a $1,000 good fund. Position 5 is reset further notice with a $3,000 total SOB through pretrial. Position 6, reset further notice with a $3,000 SOB through pretrial. Position 7 is reset further notice with a $3,000 SOB through pretrial. Position 8, reset further notice with a $3,000 SOB through the jail. Position 9, reset to the SAP calendar with a $1,000 good bond. Position 10 is reset further notice with a $1,000 SOB through the jail. Position 11 is going to the SAP calendar with a $1,500 total split bond. Position 12 is reset further notice with a $1,500 total SOB through the jail. Position 13 is going to the SAP calendar with a $1,500 good bond. Position 14, reset further notice with a $3,000 SOB through pretrial. Position 15 is reset further notice with a $2,000 SOB through pretrial. Position 16, reset further notice with the $3,000 total SOB through pretrial. Position 17 is going to the SAP calendar with the $2,500 split bond. Position 18, wait a minute.
5,000 cash is what I got.
Okay, that you're correct. It's going to the
Everybody else got that?
SAP calendar, yeah. It's going to the SAP calendar with a $5,000 cash bond. And again, the SAP date is August the 16th. Position 19 is reset further notice with the $1,000 SOB through the jail. Position 20 is going to the SAP calendar with a $1,500 total good bond. Position 21 is reset further notice with a $2,000 total SOB through the jail. Position 22 is being reset to the calendar tomorrow. It's a medical reset. Position 23 is reset further notice with a $3,000 SOB through pretrial. Position 24 is reset further notice with a $2,000 total SOB through the jail. Position 25, reset further notice, a $3,000 SOB through the jail. Position 26 is going to the SAP calendar with a total $3,500 good bond. Position 27, reset further notice with a $1,500 total SOB through the jail. Going to the add-on calendar, position number 1 is a $3,000 SOB through pretrial, and position number 2 is reset further notice with a $2,000 SOB through pretrial. Are there any comments, questions, or otherwise?
I'm good.
We're good?
Okay.
Okay, we're good.
We'll
Everybody
see y'all
take care.
tomorrow.
Okay.
Have a good evening.
See you.